there? I was gonna see if maybe we could get the staff's exhibits name to help when we introduce them. Are you concerned about that at all, Patrick?
No,
Okay.
because we're about to be on YouTube also, by the way, just for everybody's awareness. No, I'm not concerned because we're gonna, I think, ostensibly admit everything at once, and then we can refer to the testimonies in our discussion. And then,
So you don't think we need to name each of the exhibits that is admitted for the record, which is what I saw done in 2489 when they did this?
It would
uh,
probably help for clarity, you guys, if
I
I,
think we
yes,
need.
I think for well, everything is numbered except for staff's exhibits.
I can do that. I'm just gonna number them really. Well, it'd be
Okay.
changing stuff that people have viewed, but um,
there's an exhibit list. I'll remind you that I don't, maybe you have them already of the SPS exhibits. And so they're saying one is the application and two is the errata.
yeah, it's staff that didn't give us an exhibit list
Okay.
and they didn't name their files. That's our issue.
Oh, it's staff. Okay. I didn't even print
Yeah.
that one.
Hi, Melissa. I'm Kevin, by the way, too. I should
Yes.
introduce myself. So nice to
I
meet you.
Nice to meet you. I recognize your name.
Yeah, I
Why?
used to be at the Attorney General and I was in
Okay.
cases litigating on that side, but then I was hiding in the background over here at the commission for the last 2.5 years. So
Okay.
now I'm in the visual sphere again.
I need to make sure I don't have your name as, oh, I sure do. Let me fix it.
Oh yeah, with an E there, right? It's got that.
Yeah, that's embarrassing.
Mm-mm. I used to joke with my dad. He said, I wanted you to be unique. And I said, well, you just give me extra work and the people around me a little bit of extra to do every day of my life.
Yeah.
All right, let's see here. Maybe I can just. And Patrick, are we already on YouTube just to know? Or are you going to let us know as soon as we're there?
Yeah, we're on. Anna just put us on a couple moments ago.
Okay. All right, great. Um, I'm going to give you a quick call then. Okay, sir?
Sure, that's great. Okay, we'll go offline for just a few moments, Ms. Gonsalves.
Okay, very good.
Good morning, everybody. It's 9 o'clock. Very good to see you and happy to be with everybody here today. Let me admit Miss Hardy. I believe everybody has now been admitted. So uh, we're on YouTube. We're live and streaming just for everybody's situational awareness. I thought before we get started here with our evidentiary hearing on the record, just as usual, check in if any parties have any procedural issues or housekeeping matters that they'd like to discuss. Ms. Hardy indicated that Mr. Gable is indisposed until shortly after the lunch hour, so we're aware of that and happy to make accommodations. But if there's anything else that the parties would like to discuss before we go on the record, we're happy to hear what those concerns or thoughts may be.
Hearing examiner Shaver.
Good morning, Mr. Rushoff.
Good morning, Austin Rushoff on behalf of the New Mexico Large Customer Group. Just one quick question. I understand that there are no questions for our witness, Ms. Hashlamon, and I instructed her that she's maybe excused. I just wanted to confirm that she doesn't need to plan to appear today for any reason.
Yes, from my side. I'll also we're off the record and a bit informal here, but I was going to make a formal introduction to everybody. We're joined here by hearing examiner Kevin Getko, and he, I don't think, has any questions for Ms. Hashelmoon. Is that correct, Mr. Getko?
That's correct. The only thing I included in an email at the end of the day yesterday was that should questions go in a direction where it, became helpful to ask questions of her, that we would try to do our best to coordinate with some timing and give enough notice and have that occur in that manner.
Excellent. Well, she's standing by if that occurs, so thank you.
Thanks, Mr. Rushoff. Anybody else? Ms. Amer, good to see you.
Yes, good morning, Hearing Examiner Schaefer. Judy Amer, representing Utility Division staff of the New Mexico Public Regulation Commission. I had a similar question about Elizabeth Acosta. She is not participating because from the email, it appeared that there were no questions for her. Second, I would like to inform the hearing examiners that staff witness Darren Zigich was the only staff member that participated in the bench request questions and responses, as during that time period, Wednesday, Thursday, and Friday, Mr. Tyler Crespin was not working. He was on leave. So he has no, it would be best for those questions to be directed to and answered by Mr. Zigich.
Thank you, Ms. Amer. And to your first point, your understanding is correct. Neither I nor hearing examiner Getko have any questions for Ms. Acosta. So that's understood correctly. And on the second point, we understand that as well. So thank you for that clarification.
Mr. Examiner, I
Hi,
have
Ms.
one.
Hardy. Good morning.
Good morning. I just wanted to confirm that with respect to the order of witnesses, since Mr. Gable isn't available until this afternoon, is the plan to proceed with the order that was included in the email and then just move Mr. Gable?
That's correct. Yes, we'll
Okay.
proceed as the Mr. Getko indicated, or as we indicated, and then we'll slot Mr. Gable in according to his availability.
Perfect. Thank you very much.
And
Thank you,
Miss
Mr. Getko.
Ms. Hardy, do you have a more detailed sense of when Mr. Gable will be available? You said afternoon now, and yesterday you said after lunch, so just kind of curious what that timing is.
I think by 1 p.m. he'll be available. At 1 p.m.
Okay.
Yeah. Thank you.
Thank you, Ms. Hardy. I have a few housekeeping things just to discuss briefly before we start, but just making a final call for any thoughts, considerations, comments before I share my thoughts. Okay, well, once again, thanks everybody for being here. Just a couple housekeeping things. First of all, I just want to introduce everybody to our court reporter, Miss Gonsalves here. She's one of our longtime partners, and we're happy to have her. I'll also mention that Miss Gonsalves has another commitment at around 4 p.m. New Mexico time. So we are endeavoring to proceed and conclude our evidentiary hearing by that time. So, hearing examiner Gecko and I take great care to preserve everyone's time and to provide a very businesslike and efficient hearing as possible. So we'll endeavor to do that and count on your cooperation for that as well. Also, we're this is a bit of a different kind of hearing. It's not contested, so we'll make a lot of, I think, efficiencies up on that as well. Hearing examiner Gecko and I just really wanted to have this hearing to discuss some of the details with the parties regarding the stipulation. I'll also say finally that we are going to once we get on the record plan to introduce the evidence and stipulate to that. So that I think should also make up some time. So with that being said, Mr. Gecko, do you have anything final to say before we go on the record here?
I do not.
Okay, great. So let's go on the record, Ms. Gonsalves.
Yes.
Are we ready to proceed? Thank you. Well, good morning, everybody, and welcome to the case number 250085 UT for an evidentiary hearing. We're in Santa Fe, New Mexico. The time is 9:07 a.m. I'm hearing examiner Schaefer, joined by hearing examiner Getko. We're here specifically for this case in the matter of Southwest Public Service Company's application requesting approval of 6 long-term purchase power agreements for battery energy storage systems and other associated relief. The hearing examiners note that notice was given by SPS of this application and was confirmed in its affidavit filed in this docket on January 21st, 2026. I'll also say for the record that we're here today in this hearing pursuant to the unanimous comprehensive stipulation also filed in this docket on April 10th, 2026. I'll mention again, just by way of housekeeping, that we're going to try to take breaks around every 90 minutes, 75, 90 minutes, depending on the flow of the witnesses and the discussion. That'll give time for everybody to take a break and catch a breath. Most of all for our court reporter, who is paying very close attention to the proceeding. Now, I'll just also say again for the record here that we're planning to proceed with SPS witnesses first, starting with Ms. Lees, then with Mr. Cecil, Mr. Trowbridge, and Mr. Gable. As indicated by SPS, Mr. Gable has availability after approximately 1 p.m. today, so we will hear from him as the schedule permits. Then we will proceed with staff witnesses, Mr. Zigich, Mr. Crespin, and then if there's questions, we will also proceed finally with OPL witness, Mr. Lee. So with that being said, I think we discussed also with the parties to stipulate to the admission of all testimony that was filed in this case. I don't believe that there's any objections to that. And I would just ask if the parties have any objections to that now, or if we can proceed to admit that evidence into the evidentiary record. Hearing no objection, then let's just proceed a bit methodically and identify the exhibits and testimony that we plan to stipulate into the evidentiary record. I will say, just by the way, that staff's exhibits or testimony that was uploaded was not numbered in the Dropbox. So let's make sure in the future to have that. It's just easier to identify for the court reporter and for our filing purposes. But we can, I believe, start with SPS Exhibit 1. Is there any? Yes, Miss Amer.
Yes, I apologize. I did number them on the actual PDF.
Okay.
At the header, and I thought that that was what was required, but I will put it in the title of the document as well in the future.
Yes, no worries. And I'll just say also for everybody's awareness, identifying the number of the testimony or the exhibit that's uploaded to Dropbox or proffered to be offered into the evidentiary record really helps with the efficiencies of record keeping and other matters associated with that. So thank you, Ms. Amer. We'll take note of it in the header and proceed in that fashion. So do the parties stipulate to the SPS Exhibit number 1, the application? No objection. It's admitted. SPS Exhibit number 2, the errata. That is admitted. SPS Exhibit 3, direct testimony of Miss Zoe E. Lees. That is admitted. SPS Exhibit 4, testimony in support of unanimous comprehensive stipulation of Miss Zoe E. Lees. That is admitted. SPS Exhibit 5, direct testimony of Justin Gable. That is admitted. SPS Exhibit 6, testimony in support of unanimous comprehensive stipulation of Justin Gable. That is admitted. SPS Exhibit 7, direct testimony of Travis Whalen. That is admitted. SPS Exhibit 8, direct testimony of Levi J. Cecil. That is admitted. SPS Exhibit 9, testimony in support of unanimous comprehensive stipulation of Levi J. Cecil. That is admitted. And we just have a few more here from SPS. SPS Exhibit 10, direct testimony of Alexander Trowbridge. That is admitted. SPS Exhibit 11, direct testimony of Jared Cooley. That is admitted. SPS Exhibit 12, direct testimony of John Teisling, Dr. John Teisling. That is admitted. SPS Exhibit 13, unanimous comprehensive stipulation. That is also admitted. Now, moving to staff exhibits, testimony of Tyler Crespin in support of unanimous comprehensive stipulation. That is admitted. Direct testimony of Tyler Crespin. That is admitted. Prepared direct testimony of Darren Zigich. That is admitted. Prepared direct testimony of Elizabeth Acosta. That is admitted. And the testimony of Darren Zigich in support of the unanimous comprehensive stipulation and responses to hearing examiner's bench request. That is admitted. Moving to New Mexico. Yes, go ahead, Mr. Hearing Examiner Gecko.
For our court reporter, would it be helpful to know the exhibit numbers of those 5 exhibits that were just admitted for staff? I was able to look inside the documents and get that information while Mr. Schaefer was doing that.
Sure, if you would like to provide that, that's fine.
So the testimony of Darren Zigich in support of the stipulation is Exhibit 1. The testimony of Mr. Crespin in support of the stipulation is Exhibit 2. The testimony of Mr. Zigich, the direct testimony of Mr. Zigich is Staff Exhibit 3. The direct testimony of Mr. Crespin is Staff Exhibit 4, and the direct testimony of Miss Acosta is Staff Exhibit 5.
Thank you.
Thank you. Now for New Mexico Large Customer Group, we have exhibit number 1. That is the testimony of Ms. Hashlamoon. That is admitted. We also have New Mexico Large Customer Group exhibit number 2. That is the stipulation testimony of Ms. Hashlamoon. That is admitted. Moving on to Occidental Petroleum, we have a direct testimony of Mr. Lee. That is admitted. And I believe that's all, except Ms. Hardy, is the response to the bench request, was that uploaded to the Dropbox and admitted just now?
Hearing examiner Schaefer, the responses are included in our stipulation testimony.
Okay, excellent. Thank you.
Sure.
Okay, now also just wanted to make sure that pursuant to our commission rules of procedure that all parties have had an opportunity to review the responses to the bench request and make any objections or motions. Is that correct? So that there's no objection to admitting the bench responses to the bench request? Okay, well, excellent. I think that's all that I wanted to go through, and I believe now, unless hearing examiner Gecko has any other thoughts, we can proceed to SPS's first witness. Mr. Gecko, do you have anything to add at this point?
I do not. Thank you, Mr. Schaefer.
Okay, thank you. Go ahead, Ms. Hardy.
Thank you. Dana Hardy on behalf of SPS, and also appearing with me is Mr. Matthew Larson. And our first witness is Ms. Zoe Lees, and Mr. Larson will be presenting Ms. Lees as a witness.
Thank you, Ms. Hardy.
Good morning, hearing examiners. Good morning, Ms. Lees.
Good morning.
Can you please state and spell your name for the record?
My name is Zoe Lees, Z-O-E, and my last name is L-E-E-S.
Did you want me to swear her in first, or are we going to do that?
Yes, Ms. Gonzalez, thank you.
Sorry.
Yes, please, go ahead. My mind
Raise-
was in stipulation. Go ahead.
That's okay. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. And Ms. Lees, what is your role at Southwestern Public Service Company?
I am Regional Vice President of Regulatory Planning and Policy. I'm also Interim Regional Vice President of Regulatory and Pricing.
And do you have before you what's been marked as SPS Exhibit 3, your direct testimony, and SPS Exhibit 4, which is your testimony in support of the unanimous comprehensive stipulation?
I do.
And with those already being admitted into the record, hearing examiners, I believe Ms. Lees is available for questions.
Thank you, Mr. Larson. Hearing examiner Gecko.
Yes, thank you, Mr. Schaefer, hearing examiner Schaefer. Good morning, Ms. Lees. I have a few questions for you this morning.
Good morning.
Good morning. My first question is in SPS Exhibit 1, which is the application at page 9, paragraph 24. And I'm scrolling there as well while you.
I'm there, hearing examiner Gecko.
Great. It's the paragraph states SPS is not irrevocably obligated to purchase energy under the LTPPAs until they are approved by the commission. Can you explain that state to me? Is SPS obligated to purchase energy under these PPAs? Like, is there an obligation to cycle the batteries a minimum amount?
Hearing examiner Gecko, SPS witness Levi Cecil can answer questions about the terms of the PPA agreement in detail. But in general, what this paragraph is saying, that until we have sufficient regulatory approval of these contracts, SPS has no obligation to perform under those contracts.
Okay. I may ask. Okay, I appreciate that. Thank you. Then my next question goes to SPS Exhibit 13, which is the stipulation at page 6. It states there that SPS agrees to perform and provide in the July 2028 required compliance filing in case number 13-00031-UT, a cost benefit analysis that reevaluates whether continued participation with Southwest Power Pool is in the public interest, including an assessment of the Southwest Power Pool's methodology for calculating the accredited capacity of renewable resources and best resources. Based on that, my question is, can you tell us a little bit about how the process goes at the Southwest Power Pool, the SPP, for setting the accredited capacity of a resource?
Hearing Examiner Getco, SPS witness Justin Gable can walk you through that process and how the SPP sets the accreditation for specific resources.
Okay, thank you. And when I'm just quiet here, it's because I'm taking some notes. Would Mr. Gable also be the right individual to ask regarding the ability of SPS to affect that rating through that process?
Apologies, Hearing Examiner Getco. I'm not understanding what you mean by affect that rating. If you mean our ability to consider the accredited capacity in our resource planning, the accredited capacity of certain resources in our resource planning, Mr. Gable is the witness to discuss that.
Okay, and just for clarity, my question was kind of directed at, and so I'll just go ahead and ask you, and you can redirect if needed. Do you know if the process at the SPP, whether SPS would be able, has a role in setting the methodology for establishing that accredited capacity that SPP uses?
Mr. Gable can discuss SPS's participation in the discussions surrounding how SPP should be accrediting capacity to resources.
Okay, thank you. Okay, the next question I have, I'm going to go ahead and read it. It refers to the testimony by staff witness Zigich in support of the stipulation.
Mr. Hearing Examiner, are you
Yes.
referring to my testimony?
No, I was going to go ahead and read a small portion of Mr. Zigich's testimony
Okay.
and then ask you a question based
Okay.
upon that.
Okay.
And if we need to refer to it, we can go there, but first I'll just read it. And what Mr. Zigich testifies to is he states, quote, based upon my further review of the penalties, which SPS refers to as adjustments, I acknowledge now that they can act as both a credit or a debit, and that they are limited in scope and value. For this reason, staff believes the issue is better suited for a thorough assessment in the current or future rate case, and thus was not made a condition of the stipulation. Staff does not believe this issue can be adequately addressed in isolation in this stipulation. Further, how these adjustments will unfold is difficult to assess at this time because it is pre-operations. That is why the next rate case would be the best time to assess this issue, end quote. And the reference there is made to the service values that are allowed for the batteries, the 51% service COS, but I'm forgetting what that stands for just at the moment. But are you familiar with what I'm referring to?
Generally, Your Honor, I believe Mr. Cecil addresses this in his testimony and might be able to answer more detailed questions.
My question, I'll give it a shot first, would be if an evaluation was done in the next rate case regarding these penalties or adjustments, depending on who refers to them, what could be done about them? Could anything be changed with respect to those adjustments or penalties that are established in the LTPPA contracts that are under consideration in this case?
And apologies, Your Honor, because I don't have Mr. Zigich's testimony in front of me, I'm getting a little bit confused in terms of the issue that you're referring to. I will state in my testimony, I discussed the process in which we have an independent auditor looking at any adjustments that need to be made to pricing due to market conditions and tariff changes. And that process is built in to the contract so that there is efficiency in evaluating whether those adjustments are prudent by an independent evaluator. And then that information, of course, can be reviewed by the commission in a rate proceeding. But it's our expectation that if the process in the PPA is followed, that there shouldn't be an issue with the independent evaluator's determination on whether any tariff price changes are acceptable or not to be passed on.
Okay, thank you for that. I'm gonna bring up Mr. Zigich's testimony then to just make it clear for everybody. So I downloaded it from the Dropbox just now, and I'm taking myself to that location. So I'm gonna go ahead and share my screen. I was hoping it was right there in it, but so can you see my screen that shows the testimony of Darren K. Zigich in support of the stipulation?
Unfortunately, I'm not seeing any shared screen yet. Oh, it's loading, sir.
There. Okay, so now you can see it.
Yes.
And what in the answer that you just provided, what I understood you to be speaking to is possible increases to contract amounts based upon tariffs or other governmental actions that might occur. And what I've understood this testimony to be with respect to starting at line 14 is penalties or adjustments related to, and I can just bring it up in another document for myself and get the exact language. Please bear with me. I think everybody here understands the amount of things that you keep together when you do this. So there's testimony in the record regarding these penalties or adjustments for the annual throughput limitations upon the batteries, which have been set at 51%. And my understanding is that this testimony here that we're viewing on my screen is with respect to the adjustments that the contracts allow for if the 51% limitation is exceeded with respect to those. So juggling screens here again. With that background, and this testimony then, which is on two screens, staff testifies that they believe this. Staff had testified to a need to define the recovery method of the potential penalties or adjustments. And staff now testifies that this issue is better suited for a thorough assessment in the current or future rate case. And based upon that deferral to a rate case and these adjustments that are defined within the contracts, my question is, given that that 51% limit is established in the contracts that are under consideration for approval in this case, if those contracts are approved, could anything be adjust those penalties and adjustments that are established in these LTPPA contracts in this case, based upon an analysis that's done in a future rate case or current rate case?
My understanding is that in a future rate case, you can't adjust the terms of the contract that's going to be approved in this case, but that as these adjustments are flowed through operationally, those can be examined in a future rate proceeding.
And when you say examined, could you help me understand what that would mean?
The parties will have a chance in rate proceedings after this case concludes to look at those and evaluate them for prudency.
And if a determination was made that those adjustments were not prudent, but they were approved in the contracts in this case, if the commission chose to approve them in this docket and the examination determined that they were not prudent in a future case, in a future rate case, would the commission have the ability to order that those penalties not be charged to SPS's ratepayers?
So I'm trying to be very precise. The terms in the PPAs can, if approved as part of the stipulation, cannot be, I don't think it would be appropriate for them to be re-examined as whether or not they're prudent in a future rate case. However, how the adjustments are flowing through to customers can be examined.
And could it be examined whether those adjustments should flow through to customers or flow through to shareholders of SPS?
I guess I'm not understanding
Well,
the
you
question.
made a statement that based upon that examination, then there could be an assessment made as to how to flow through, I believe you may have said.
I guess I'm referring to like whether they're accurately calculated.
Okay.
And yeah.
Would assignment of those costs, assuming that the calculation is correct, be an item that could be decided in the future, or is the assignment of those costs established as going to ratepayers based on approval of the contracts in this case?
So the adjustments here, my understanding, are referring to credits or debits on the recovery of capacity charges. Perhaps I'm not understanding exactly what you're asking, and my apologies for that, hearing examiner. But my testimony is, in a future rate proceeding, if the commission would like to make sure that the credits or debits to that capacity charge to customers has been accurately assessed, that I think would be appropriate for that future proceeding.
And I'm sorry to, my questions might not be clear enough, and so I'll give it one more shot. Let's assume it's an additional charge, and it's not a credit from the developer to SPS. So it's run on an annual average of 53% instead of 51%. So there's additional charges that are then charged from the developer NextEra to SPS based upon the annual review. And let's just hypothesize that that's $100. I have no idea what those values are. That $100, when assessed in a future rate case and determined to be an accurate assessment of what those charges should be, in alignment with what this contract is, what the contracts for the 6 BES are. If that's accurate and it's $100 charge being charged to SPS, would the commission have the ability in that rate case to choose whether to assign that $100 charge to ratepayers as opposed to shareholders, or would they be limited? Would the commission be limited to determining how to assign that $100 to ratepayers only?
My testimony that at that time it would be considered part of the capacity charges for the resource that's recoverable from our customers for the energy that capacity and energy that we're providing them from these resources.
Okay, great. Thank you. That definitely answers my question. Thank you very much. Thank you for working through that with me.
Yeah, apologies for any confusion on my end.
I'm going to stop sharing my screen then. Okay, does everybody have me back on the screen? My next question refers to SPS Exhibit 4, which is your testimony in support of the stipulation. And I refer to page 34, lines 9 through 11.
Yes, sir.
Okay. And you spoke a little bit about this already, but it was in the context of another question. And so what I have here is, I put a quote: "The requested rate increases for a new or modified tariff will be verified by an independent auditor, but will not be presented to the commission or to staff and interveners for review prior to their going into effect once verified." End quote. So this refers to possible price increases due to imposition of tariffs, hypothetical impositions. My question is, and I didn't locate this, it might be in the application. How is the independent evaluator selected?
And Mr. Cecil might be able to provide further detail, but it's my understanding that SPS has an independent auditor that it will use. SPS selects the independent auditor.
Okay, just to clarify, is the independent auditor already identified, or would that be a selection process after the conclusion of this matter or upon the event of tariffs leading to cost increases?
I don't know whether an independent auditor has been selected or not. I think there's a process in which you need to make sure that the entity that conducts that function doesn't have any conflicts. And I don't know whether SPS or Excel Energy has gone through that or not, that process yet.
Okay. Is that an internal process to SPS to do a verification of no conflicts? Or would that be a process that would involve commission approval of the independent auditor?
I don't know of any process that requires commission approval of the independent auditor, and Mr. Cecil can talk about the process in which the company has selected independent auditors for these purposes.
Okay. Has SPS selected independent auditors for its New Mexico jurisdiction for a similar situation in the past?
I'm not aware of selecting independent auditors for our New Mexico jurisdiction hearing examiner. I am aware that we have this structure in place for our public service company of Colorado.
Would SPS be opposed to presenting the independent evaluator, well, auditor, I'm sorry, I made a note there, be opposed to presenting the independent auditor to the commission for approval, along with the evaluation of whether there are conflicts that you spoke to a possibility of existing?
It's my understanding, and you'll have to talk to Mr. Cecil more about this, but that is not contemplated in the contractual terms in the PPA. And it's our obligation under that agreement to follow the negotiated terms.
Are there terms in the contract that speak to the approval of the independent auditor?
You'll have to ask Mr. Cecil about specific terms in the PPA contracts, Mr. Hearing Examiner.
Thank you. I'm going to take a couple notes here real quick. And just out of curiosity, does Zoom let you hear my keyboard or not?
I can't hear your keyboard, Mr. Hearing Examiner.
Okay. I may need to come back to that, but we'll see.
I will add on the terms of the PPA. These PPAs were provided in the draft RFP documents, and SPS did not receive any comments from stakeholders or staff on the terms of those model PPAs. So no one provided any feedback on those terms.
Understood. Understood. Thank you for that. I'm going to move along to the next question then, and refer to you to Exhibit 4, which is your testimony in support of the stipulation. And still here at page 34, moving on to line 11, going through 35 at line 2. And I'm going to read a quote from there. It says, quote, "The rate increases will be presented by SPS in the appropriate future base rate or fuel and purchase power cost adjustment clause proceeding, in which staff and interveners may review the revised LTPPA rates and supporting information provided to the independent auditor by the seller. The commission may also review such information. Staff and interveners may potentially raise prudence challenges to the rate increases at that time, although SPS believes such challenges are unlikely to be necessary given the approval of the mechanism in the LTPPAs, end quote. So with respect to that, I have a few questions. First, can you speak to what determines where those costs would be presented as to a base rate proceeding versus an FPP CAC proceeding? Because there's an or there in that first sentence that I read.
Yes, hearing examiner Gecko, just as a point of clarification, the testimony you were reading continues on to the next page to finish out that sentence. But as part of the stipulation, the parties have agreed to allow the capacity costs for these LTPPAs to be recovered through base rates, and the energy costs for these LTPPAs to be recovered through FPPCAC. Trying to say it slowly for our court reporter. And depending on where those future increases lie, that would be the rate proceeding that you would consider them in.
Okay. The rate increases discussed in the quotation there, starting at 3411 and going over to 35.2. Those are with respect to increases to capacity costs, was my understanding. Is that correct?
Mr. Cecil can talk a little bit about how this particular mechanism works in the contract itself. My understanding is the mechanism will capture any increases related to market volatility, such as tariff increases.
Perhaps it's a question for Mr. Cecil then. I didn't think I would have this question, and so I think I'm probably confused. Is there an understanding that fuel prices may increase due to tariffs and affect these contracts?
I see what you're saying. I guess it would be my expectation that we would address these in a rate case.
Okay, thank you.
But if it's appropriate to address it in an FPPCAC, I suppose that we would address it there as well.
Okay, thank you. If something needed to be addressed in an FPPCAC proceeding, are you referring to a proceeding that approves the FPPCAC adjustment mechanism, or are you referring to, and I apologize for not knowing this, what may be a 3-month true up or a monthly true up, or I simply don't recall how often the true ups are done for SPS.
I'm referring to the proceeding in which the mechanism is approved, so not a true up.
Okay, thank you. Okay, now my next question is, and I know my understanding is that you aren't testifying as an attorney in this matter. And so I'm not asking this question to you as an attorney, but what is your understanding for the apparent assertion that the approval of the LTPPAs in this proceeding would provide a prudence determination for the rate increases that are discussed here?
So as I state in my testimony, the approval of the LTPPAs includes approval of the new trade measure event provision in the contracts, which when executed has an independent auditor doing that prudency review of any increases under that provision, and that approval of these LTPPAs would be approval of that process. And of course, as I state in my testimony, that the commission can review the information regarding any approved increases by the independent auditor in a rate proceeding. And of course, staff and interveners can potentially raise prudency issues at that time regarding any rate increases associated with that process. But it's our position that any challenges to those rate increases would be unlikely, just given that we have this process built in to the contracts to assess whether those increases are prudent at the time that the seller brings them up, and that they would be verified by an independent auditor.
So when that independent auditor would make that determination, and then parties are allowed to review that determination of prudence, is that determination a rebuttable determination of prudence, or is it your position, is it the company's position that it is an irrebuttable determination of prudence?
It's my position that that determination is presumed to be prudent. Hearing examiner.
Does presumed mean it can be rebutted or not rebutted?
As I state in my testimony, parties, of course, they can raise challenges in those proceedings should they feel it's necessary.
Based upon those challenges, could a determination be made by the commission that those adjustments, those rate increases, were not prudent and therefore cannot be collected from ratepayers?
My expectation is that if the commission approves this process, that they would look at the information provided by the independent auditor, and unless there is something unless there's evidence that that determination was inappropriate, then the commission would presume that determination to be prudent.
So if there was evidence that weighed by a preponderance of the evidence that it was not prudent, could the commission order those charges, those rate increases, not to be charged to ratepayers?
I think that would be a determination by the commission at that time, whether it was appropriate or not. But what I will say in practice, Your Honor, at PSCO, the independent auditors do not always approve these increases. So it's not, in practice, these new trade measures are being scrutinized very carefully by our independent auditors, and it's not a given that they get approved.
Okay, thank you for that. Okay, I'm going to move on to my next question. Thank you for stepping through that with me. Um, so, in this world we operate in here, there's always zones of reasonableness, and that translates into zones of prudence. And that's never perfectly defined. That's what we work to do in these cases. And so, given that, given the fact that these cost increases have to be reviewed by an independent monitor, and there are therefore degrees of increases that could be deemed to be reasonable and others that might not be, just hypothetically. Can you address my concern that I don't understand the incentive that there is for SPS and NextEra to fight hard to keep these cost increases down when there's a tariff event, for example? Let's say there's a zone of reasonableness of, X% to Y%, but Z wouldn't be reasonable. And there's a choice there between X and Y. I would feel more at comfort if there was incentive mechanisms for fighting to keep those costs low. Are you able to speak to that and maybe educate me as to how the process goes? I'm learning that, there's a process evidently in action in Colorado, and whether there are mechanisms that are put into place to minimize the amount of cost increases that might be deemed prudent by the independent auditor.
Mr. Cecil can perhaps talk a little bit more about how that process works in detail, but Ms. Hearing Examiner Getko, what I will say generally is that there is market volatility and geopolitical events that take place in the market right now that are beyond SPS's control and are beyond NextEra's control. And that is the reality of our market today. I think the independent auditor mechanism that we have in place here incentivizes NextEra to try and mitigate that as much as possible, because it's not a given that those will be found prudent. So I think that in that respect, we have put that type of mechanism into the contract itself. But we have capacity needs on the system today that are real. We have customers waiting to be connected. We have reliability requirements that we as a company must meet to the best of our ability. And we need to put a structure in place that acknowledges the fact that there is market volatility right now that is beyond our control, but that allows us to move forward with these resources in a prudent manner for our customers.
Yeah, I appreciate that. Thank you, Ms. Lees. With respect to that, when there are these events that are out of the control of the company on a global scale, when those events occur, would it be normal that NextEra would come to SPS with a proposal for what the price increases must be as a result of that, and that SPS might enter into negotiations as to whether the presented values from NextEra should be accepted on their face, or whether there are discussions as to whether that would be appropriate, or maybe a smaller amount might be appropriate?
Mr. Cecil is the witness that can talk to how negotiations of these contracts work. Mr. Goodko.
Okay, thank you. Take a few notes here. Okay. Thank you. I'm going to move on to the next question. And So in, so at some point I mislabeled one of these. Your testimony in support of the stipulation is SPS Exhibit 4. Okay, so still here in Exhibit 4. On page 40 now, at lines 7 to 8. And then I'm also going to end up taking us to page 41 and 43. And they're very short quotes, so I'm going to go ahead and just read them here. And at page 40, you state, quote, imputed debt and its effects are a broader issue, and there is not an explicit provision in the stipulation that addresses imputed debt, end quote. And page 41 at lines 15 through 16, you state, it is true that the 15-year LTPPAs in this case will create imputed debt, end quote. And then at page 43, lines 5 through 6, you state the 15-year term for the BESS LTPPAs helps manage the negative credit metric effects from imputed debt by avoiding a finance lease designation, end quote. What I see there is, measures being taken to mitigate these impacts, but a recognition that there are impacts. And one thing that a little bit that I reread the rule yesterday, and 17.9.551.8 states, and I can read that provision of the rule. It states, an application for commission review and approval of an LTPPA shall be accompanied by supporting testimony and exhibits that provide evidence of the LTPPA's impact on the electric utility's financial condition and financial metrics. I wasn't able to locate, and maybe I should be more specific here, but is there a specific understanding by SPS in the application or the testimony in this case as to the negative credit metric that will actually result from an approval of these BESS LTPPAs?
Hearing examiner Gedko, I don't know that we're able to say our credit metrics will be affected in this way, but in my direct testimony, I do, and excuse me, I'm finding the exact page for you. I do identify on page 58 that the LTPPAs are expected to add approximately $640 million of imputed debt in the calculation of SPS's credit metrics. And that's what credit agencies will look at when it's evaluating. That's one of the things that credit rating agencies will look at when evaluating SPS's credit metrics and how these LTPPAs affect those metrics.
And so that's testimony on the calculation of what the imputed debt is there testimony, or has there been analysis done that's included in the application and testimony as to what the effect of that imputed debt will be on SPS's financial condition and financial metrics?
Again, Mr. Hearing Examiner, on page 57 of my direct testimony, I provide testimony on the impact of the financial conditions and metrics. Again, those metrics are determined by credit rating agencies.
Okay, let me catch up here.
And in general, it is SPS's position that by setting the term of these contracts at 15 years, we are mitigating any negative impacts to our credit metrics. And of course, there are other factors that can mitigate that as well that are outside the scope of this proceeding.
Thank you. Thank you for pointing me to page 57 there. And your question that you write is, will the LTPPAs impact SPS's financial condition and financial metrics? And then your answer states that SPS has examined the impact of imputed debt related to the LPPPAs on its financial metrics. Does the application and testimony contain information as to what the impact of that imputed debt is? That's the piece I didn't locate.
Yeah, it's my testimony that credit rating agencies like Standard & Poor that I talk about in my testimony will then have that $640 million of imputed debt as one of the items that they look at when they're setting those ratings.
And so did you do an analysis of how it would affect their ratings? That $640 million in imputed debt? Like, did SPS do investigations to understand or analyses to understand what an actual numerical impact of that imputed debt is? Or did it stop at, they're going to take imputed debt into account, but we don't know what that means?
I don't know whether our Treasury Department in the company did any specific analyses that you're talking about, Mr. Getko, or whether those are possible to do given that credit rating agencies are the ones that make these determinations. But in general, the company is very aware of the fact that we need to be cognizant of how these types of agreements can affect our credit metrics. And we are aware that imputed debt can negatively affect our credit metrics, and we need to mitigate any negative effects, which is one reason that we set the PPA term at 15 years. However, the only way to fully mitigate this would be to not allow PPAs to bid into our competitive procurements. That would have an effect on the competitiveness of these RFPs, and it's my opinion runs counter to the policy of the state in terms of incentivizing competitive procurements for generation. So SPS knows that when it brings on a PPA, that we will have imputed debt considered by credit rating agencies when they are making these determinations. And we try to take prudent measures in order to mitigate any of that. 15-year PPA term for this specific technology is one way to do that. Timely cost recovery is one way to do that. So the provisions in the stipulation regarding cost recovery through base rates and the FPPCAC are productive. And I think that SPS and the parties here have been prudent in considering what that impact will be.
Thank you. Thank you for that context. And Another question that's somewhat similar. We've discussed a few minutes ago, possible cost increases related to the 51% limitation for throughput, for example. And now we're discussing, impacts to credit metrics, and that, by my understanding, would ultimately affect rates. Otherwise, they wouldn't be of concern. So reading the rule yesterday again, 17.9.551.8 D4, it requires an estimate of the effect on rates to customers. I know that there's been testimony provided with respect to what the capacity costs of these particular contracts have an effect on rates. Have there been analyses done for overall effect on rates that may result from changes to credit metrics?
Hearing examiner Gedco, that type of analysis is typically done in a rate case so that it can take all of the potential impacts to credit metrics into account. And that's done by typically a witness that presents bill impacts that of the cost of service that includes a capital structure and ROE and things like that are presented by the company.
So that would be done in a rate case, but that just to have it clear is, so that type of study was not done in this case. Is that correct?
A study done based on how the PPAs, what the rate impact would be from any impact that the PPAs have to our credit metrics, not that I'm aware of.
Okay, thank you. Okay. Hopefully I don't get out over my ski tips here on this one too much. The next question is based upon your testimony in Exhibit 4, which is your testimony in support of the stipulation at page 39, line 13 through page 40, line 1. And you were responsive to certain staff testimony with respect that created a comparative commentary to BESS LTPPAs for another utility, PNM. And he stated, PNM has certain, or quote, PNM has certain 20-year BESS LTPPAs that use a different variable pricing structure. SPS is not aware of the specific reasons for PNM's choice of BESS LTPPA contract structure. SPS made a reasonable choice to limit the BESS LTPPA terms when it issued the 2024 RFP. Although variable pricing option was allowed in SPS's 2025 RFP, end quote. So my understanding from elsewhere in the testimony is that the variable pricing structure referred to here, SPS has testified to it being viable and perhaps appropriate when the BESS are co-located with an energy generating resource and the contracts for the co-located energy generating resource and the BESS are established at the same time. Is that a fair understanding?
That's my understanding of Mr. Cecil's testimony.
You may redirect me. Can you explain a little bit of the importance of the contracts being established at the same time?
Mr. Cecil will be the correct witness to ask that question of.
Yeah. And this may be for Mr. Cecil as well. And maybe to introduce some humor here, I've worked with cases that involve a company named Cecil. And so every time you say Cecil, my brain has a little bit of a hiccup.
You'll have to tell Mr. Cecil that when he takes a stand.
Yeah. So my question is this: for the 2025 RFP, where the variable pricing option was allowed, are the variable pricing structure bids limited to bids that are co-located and that are contractually linked together?
I believe you'll have to ask Mr. Cecil about that. Mr. Gable may know as well, as he is responsible for executing that RFP. But I don't know the answer to that question.
Okay, thank you. Making a couple notes here. Okay, not much more here. My next question then, I can refer to your testimony in support of the stipulation at 42, lines 8 through 12. And we may have covered this, but one statement you make there, and this is again with respect to the impact of the best LTPPAs on SPS's credit ratings, the credit metrics.
Mm.
And you said a detailed analysis of the impact of the best LTPPAs on SPS's credit ratings and how SPS might request appropriate rate-making determinations to address such an impact would be speculative at this time, but can be addressed in the future as there are multiple drivers of the overall level of imputed debt for SPS beyond just the best LTPPAs. And my only curiosity there was, can you explain why it would be speculative at this time?
Yes, Mr. Hearing Examiner. Because SPS does not give itself a credit rating, it would be speculative of us to address the impact of these contracts to our credit ratings before they're approved, because we wouldn't see that. We wouldn't see an evaluation of that impact from credit rating agencies yet.
Okay. Given that answer, does that mean that SPS wouldn't do internal analysis when it's considering the mix of resources that it will put onto its system as to what those effects would be on its credit metrics?
We certainly do an analysis, and we certainly put forward mitigations like the 15-year term, so that we can mitigate and minimize any impact to those ratings.
And do those internal analyses drill down to actual numbers?
I don't know.
You don't know. Who would I ask about that?
If you want to ask questions in regards to how our Treasury Department does this type of analysis, we would have to get you a treasury witness and make them available for you.
Would you or Mr. Cecil or Mr. Gable know whether the treasury analysts provide that information to you or Mr. Gable or Mr. Cecil?
Would we know whether they provide the information? I'm sorry, I'm not understanding your question.
So the question was, is an analysis done with respect to those hard numbers? And the answer was more or less, and I'm paraphrasing, I would need to ask a treasury analyst. But I'm just hypothesizing that if that analysis is done, the treasury analyst doesn't just maintain that information and the results of that for him or herself, for themselves. That information would be shared with individuals that make decisions with respect to the resources that are brought onto the system.
Yeah.
And therefore, then answer to an analysis of whether there's hard numbers could be answered by the fact of whether folks that select those resources, perhaps you or Mr. Gable or Mr. Cecil, see those numbers when they make a determination of which resources to pursue. Is that maybe a fair analysis? And therefore you might have knowledge as to whether hard analysis has been done as to the effect of these credit metrics?
Again, no such analysis has been provided to me on how these will specifically affect our credit metrics. Those are determined by independent agencies, not by SPS. Mr. Gable can speak to how his Encompass modeling does or does not include ways in which impacts to credit metrics can be considered. It is my understanding, though, that we as a company set the LTPPA term for best batteries at 15 years at the front end to mitigate any such impacts. I'm not aware, again, you'll have to ask Mr. Gable, that we, as part of project selection, do any specific modeling on those impacts. I'm just not familiar enough with the Encompass model to testify to that.
Okay, thank you very much, Ms. Lees. That's helpful. And we do need to take a break soon. I have 2 question blocks more. Is our court reporter okay for another 5 to 10 minutes? Is everybody else okay for another 5 to 10 minutes? Okay, thank you. Okay, still in your testimony in support of the stipulation, and now on page 44, lines 3 through 8. You provide some testimony, I quote, if SPS is ordered to enter into contracts in the future that have finance lease implications, for example, 20-year LTPPAs or even longer terms, imputed debt may rise to the level of requiring a specific adjustment to SPS's capital structure in order to limit the associated credit metric degradation. Moreover, as noted in docket number 25-00079-UT, in the direct testimony of Todd A. Weiner, the proposed capital structure of 56% is a moderate increase over the currently authorized capital structure of 54.70%. End quote. Then at page 46, lines 11 through 14, you state, quote, the credit impact of LTPPAs have not been fully mitigated and SPS's overall level of imputed debt may require further consideration of credit supportive tools in the future. One such tool is SPS's capital structure, while others are SPS's cost of capital and timely recovery. End quote. I mean, that sentence does go on there, but what I quote hopefully is enough. I don't believe I've skewed context. So my question is, can you confirm that the effect on capital structure due to the LTPPAs under consideration in this case would be to request an increase in the debt equity ratio to include more equity?
I guess that could be a way to mitigate. Well, that is a way to mitigate any negative effects to the credit metrics due to imputed debt. And I believe the testimony you quoted listed other ways that you can mitigate as well.
Yeah, okay, thank you. With respect to the other ways, I think that may be a reference to SPS's cost of capital. Can you explain what adjustment could or would be made to SPS's cost of capital to account for the increased imputed debt?
I don't know at this time.
Can you hypothesize what different options SPS might be able to bring to the table to further support SPS's mitigation of the impacts, in addition to timely cost recovery, 15-year contract term, higher debt equity ratio? What other options does SPS have to mitigate these impacts?
In terms of proactive mitigation outside of a rate case, I think that we've pulled the levers that we have in terms of setting the term of the LTPPA and stipulating with parties on rate-based recovery and FPPCAC recovery in this stipulation. I think that's very positive. As I sit here today, I'm not sure that I know of other proactive mitigations we can take at this time outside of our rate case.
Okay, and within a rate case?
It's my testimony that you quoted, sir, on page 46 goes through that. And of course, those levers that are listed on lines 13 through 16 are not only done because of imputed debt from PPAs, but from a number of other factors. So the rate case as a whole takes a holistic view. And the utility takes a holistic view in making those requests.
Sorry, I'm catching up a little bit. Can you tell me what's in the toolbox of credit supportive tools?
So I list those on page 46, line 13, when I say one such tool is capital structure, while others are SPS's cost of capital and timely recovery.
Is it limited to that, or would there be others?
There may be others that someone like Todd Werner who testifies in the current rate case for SPS can testify in detail to.
Okay. Okay. Um, my last question that I have right now is, let me make sure I haven't covered it. Oh, yeah, this is a pretty minor question. It's just to clarify something in the record. So at page 43 in your testimony in support of the STIP, at lines 10 through 14, there's a question there that says, it's the question that is in your testimony. In docket number 25000079-UT, has SPS proposed an adjustment to the company's actual capital structure in response to the imputed debt that is proposed in this docket number 25-00085-UT? Explain, end quote. And your answer states, quote, at this time, SPS does not have a specific adjustment to its actual capital structure in case number 25-00085-UT. Was that intended to state in case number 25-00079-UT, the first sentence of your answer?
No, and if you go to the next page in my answer, I address docket number 25-00079-UT and the request in that case. And I can recognize and apologize for the confusing ordering of the answer in that on page 43, Your Honor.
Thank you for that clarification. Then when you do go to discussing 2579 there on page 44 then, and you state that in the direct testimony of Todd A. Werner, the proposed capital structure of 56% is a moderate increase over the currently authorized capital structure of 54.70%. Are you providing that information to answer the question of in docket 25-0079-UT? Has SPS proposed an adjustment to the company's actual capital structure in response to the imputed debt? And end quote, I emphasize there, in response to the imputed debt.
So the purpose of that is just to identify what the request was in that case. And if you continue reading, I explain what, if any, the impact is of the imputed debt was. So the additional $640 million of imputed debt resulting from this proceeding and the capital investment relating to SPS's self-build projects pending before the commission in case number 25-00066-UT were factored into the overall adjustment into the company's proposed capital structure in case number 25-00079-UT.
Okay, thank you.
They were two factors considered of many.
Thanks for bringing me to that point. I had, gotten off on the wrong foot based on that first sentence. So thank you for that explanation.
And again, I apologize for the confusing ordering of that answer. Sometimes it makes sense when you're writing it, and in practice it's confusing. So apologies.
That's great. I appreciate you working through my questions with me. Hearing Examiner Schaefer, and you have a little bit more experience of time management. I'm at 10:34, and I believe SPS Council has the opportunity to conduct a redirect as well, and whether we should do that now or after a break.
Well, let's go to a break first, and we'll recess for 10 minutes. Remember, we're on YouTube, so make sure to mute your mics unless you want to be heard forever around the world. and your cameras as well if you wish to do that. So we'll take a recess for 10 minutes. Thank you, Ms. Gonsalves, and we'll reconvene here at 10:15. Thanks, everybody. Okay, it's 10:45. Let's go back on the record here. And Mr. Larson, I'm not sure if you have any follow-up questions for Ms. Lees, given hearing examiner Getco's questions. If you do, please proceed.
We don't have any follow-up questions at this time, hearing examiner Schaefer.
Thank you, Mr. Larson. I suppose then we're ready to hear from SPS's next witness. That I believe is Mr. Cecil. Is that correct, Ms. Hardy?
Yes, that's correct.
Okay, let's go ahead and call Mr. Cecil and have him sworn in, and then we can have Mr. Getco, hearing examiner Getco, ask the questions that he has for that witness. Thank you.
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning, Mr. Oh,
Oh, sorry, go ahead, Ms. Hardy.
do I need to do anything? Good morning, Mr. Cecil.
Good morning.
Could you please state and spell your full name for the record?
Yes, it's Levi Cecil, Leviceccil.
And by whom are you employed and in what capacity?
I'm employed by Xcel Energy as a senior purchase power consultant.
And in this case, have you provided direct testimony, which is marked as Exhibit 8, and testimony in support of the stipulation, which is marked as SPS Exhibit 9?
Yes.
And since those have been admitted into evidence, I don't have any questions for you. And hearing examiners, Mr. Cecil is available for questions. Thank you.
All right, thank you. Good morning, Mr. Cecil.
Good morning.
Were you able to listen to Ms. Lee's testimony just to know whether you heard some of the questions already that we might revisit?
I did listen, yes.
Okay, great. So then one question that I had asked was whether there is an obligation in the BESS LTPPA contracts to cycle the batteries a minimum amount. Can you address that question?
Yeah, so there is no contractual obligation to cycle a minimum amount. Now we do purchase the capacity of the battery resource. And once the contracts become fully effective and declare COD and achieve COD, at that point we are obligated to purchase the capacity of the batteries, but there's no minimum operating levels that they must operate at.
Okay. Thank you for that. I might go through my notes. The next question I had then was, are you familiar with how the independent auditor is selected that reviews the price increases that might be caused, or price decreases, I imagine, that might be caused by tariffs or other events?
Yes, I am familiar with the mechanism.
Can you explain how you choose the independent auditor, please?
Yes, the independent auditor is selected by the seller in this case. They would initiate the new trade measure event provision, and they would then send their documentation to whichever independent auditor they select. Now, there is in the contracts themselves, the independent auditor is defined as one of three options. I won't list those options. They're confidential, but they are limited on who they can select for the independent auditor.
Okay. Then does SPS play a role in determining whether to approve the auditor that is selected by NextEra?
We do not if they select from one of the stated options. If they prefer an IA that is outside of those stated options, then we would have the right to approve or deny use of that auditor.
Okay. Thank you. I'm scrolling through my notes, so please forgive a little bit of that, those notes I took. So one of the items that I asked a couple questions about was I was concerned about the incentive to SPS and NextEra to keep the price increases to a minimum within a zone of reasonable price increases, considering that the costs are passed through to ratepayers. Can you and can you first speak to just generally whether you see that there are incentives and how those are affected with respect to mitigation of those price increases through the auditing process, et cetera?
Yeah, I would say generally the contracts incentivize cost control of the resources. In this case, we are allowing some limited relief for tariff-related impacts, but there's also many other costs that the sellers are that are imposed upon the seller that are not included in that provision. So construction, development costs, domestic procurement, things like that, where there's additional costs that go into these facilities that are outside the scope of the new trade measure event provision. And so that provision was really added as a targeted, limited approach to allow them some relief if they are impacted by new or modified tariffs.
And so did I understand that correctly that there might be other costs that, can't be added into the price that NextEra would have to suffer as well if they came for a requested increase based upon the new trade measure event? Was that a correct understanding of what you just said?
Yes, that's correct.
Okay. Then the other question I had asked was, can you speak to what the negotiation process is when price increases are presented based upon a new trade measure event that SPS may have with NextEra?
To clarify, are you speaking in terms of after they've initiated a new trade measure event request?
Correct. Yep.
So under that provision, they would provide us and the independent auditor their documentation verifying that the request is valid. And at that point, both the independent auditor and SPS would evaluate their documentation. Now, the effectiveness of that price increase is only dependent on the independent auditor validating their claim and showing that there are cost impacts to the projects. So SPS does not have negotiation right at that point with the developer.
Okay, so there is not a negotiation right. If approved by the independent auditor, the proposed price increase will go into effect.
Correct.
Okay. And I understood you referenced that it's in confidential information, the possible 3 independent auditors. In general terms, without speaking to confidential information, is there any way you can speak to how the independent auditor possibilities were approved by SPS to ensure that the review of these price increases would be diligent and protective of ultimately of SPS's ratepayers?
Yes, the independent auditors that we selected for use in the contract are large multinational auditing and accounting firms that have vast experience in this area.
And so it's a typical process in many other jurisdictions. Is that fair?
Yep, that's correct. We've utilized a similar provision in all of our jurisdictions at this point.
Okay. And again, without speaking to confidential information, are you able to speak to the establishment of the upper limit of what price increases can be approved by an auditor, and whether there is an independent analysis that's done with each contract to establish that, or whether that is kind of a standard across all of your jurisdictions? I'm curious, just as an open-ended question of, how that upper limit is set and, you
Yes, I would say
Right.
generally the limit across all of our jurisdictions is in that area. It may not be exactly the limit that it is in this case, but it's generally in that region. And that's
and is that,
really, go ahead.
and is that general limit based upon prognostications of what these effects would be, or an analysis of, what the impacts could be on ratepayers and what SPS believes is, reasonable to accept? Like, how is that uniform zone that you've just spoken to kind of determined? I'm curious.
Yeah, we've used our experience negotiating contracts, especially in other jurisdictions, to kind of determine what a reasonable market value is for that percentage increase. It's a percentage that balances, keeping the projects moving forward, and allowing us to procure the capacity while also limiting the potential cost impacts to our customers.
And if that limit were set too low, is it likely that the contract price for the PPA would go up in response as a protective measure from the developer? Is that a piece that goes into that analysis by SPS?
It is possible that the cost of the contracts could increase. It's also possible that the seller may not move forward with the contracts at that point if the level is set too low.
Okay. Are there any PPA contracts being proposed out there these days in the general utility world that don't allow for these types of increases?
I don't think I would be able to speak to that in terms of Excel's other jurisdictions. We are utilizing this provision or a similar provision in all of our other contracts.
Okay. All right. Thank you for that. Okay, my next. So this was the background for this question was that the testimony in the record speaks about the variable pricing structure contracts, and it's in the record that in SPS's 2025 RFP, those have been allowed. And my understanding as a first question was, my understanding was that it's an appropriate style of contract when a BESS is co-located with an energy generating resource and when the contracts are established at the same time. Is that correct?
Yes, that's correct.
And that's different than a hybrid, where the hybrid was a term used within the testimony. In hybrid, I understand probably refers to where a single contract is made for both the energy resource and the BESS. Is that correct?
Yep, that's correct.
And so in the 2025 RFP, are bids for variable pricing structures, which are allowed, limited to just those situations, either a hybrid situation or a co-located BESS and energy generating resource with contracts that are established at the same time?
I think generally those are the types of resources where we would expect to see a variable pricing structure proposed. We are not limiting the variable pricing structure to only hybrid or co-located, co-contracted facilities. But just in terms of the mechanics of how payment would work under that kind of a resource, we typically see a variable cost approach with a hybrid or co-located facility. It's difficult to apply that to something like a standalone battery resource because there is no generation on which the capacity revenues could be built into. So while we expect to see hybrid and co-located use the variable pricing approach, we're not limiting it to those facilities only.
Okay. Okay. Thank you. I guess it's probably not, are you at a point in the 2025 RFP to know whether you've received bids for variable pricing structures that are for an independent battery energy storage system?
I think that may be a question that's better suited for Mr. Gable.
Okay. Begin a note. Okay. In SPS Exhibit 8, which is your direct testimony, you discuss on page 15 and 16 that, and this is with respect to the 3% price increase that was negotiated and accepted by SPS after the projects has been selected through the RFP process. And you state that to secure the projects and their valuable and needed capacity, and with the underlying belief that despite the price increase, the LTPPA projects would still allow SPS to provide safe and reliable electric service at the lowest reasonable costs and would not undermine the integrity or fairness of the RFP process, SPS agreed to the revised pricing. Can you explain a little bit what underlies your underlying belief that leads to the ability to accept that in that price increase, please?
Yeah, so in this case, the seller approached SPS early in the negotiation process requesting a price increase, and they were citing macroeconomic and political challenges that were present that were not as prevalent during when bids were due. And so there was kind of a change in that macroeconomic political environment where they would need a modest price increase to continue forward with the resources. We took that price increase request internally and evaluated it. Mr. Gable may be better to speak to our evaluation of the price increase, but it was determined that not only are these resources still the best options in terms of economics, but also the best options in terms of their timing as well, as their CODs are earlier in the capacity need period.
And so would that analysis have looked at and considered whether other bidders were proximate enough with respect to both cost and timing to make a determination of whether you should go back to other bidders and see if their bids would need such an increase, and therefore do a determination of whether the proper projects are still selected as lowest cost resources?
I think Mr. Gable may be able to better speak to that question.
Okay, let me get this. Mr. Gable. Okay, thank you, sir. Here's a little just a little clarifying question. You've made reference to, and so Ms. Lees as well, to the new trade measure event. In your testimony, in your direct testimony on page 15, lines 1 through 6, you state, quote, "These LTPPAs include certain relief provisions, mostly related to import tariffs on major project components, qualifying changes in tax law, and executive orders related to federal permitting." My question, end quote, my question is, can the amounts established in the LTPPAs be increased through the independent auditor process for changes in tax laws and executive orders, in addition to just tariff changes?
No, the price will not change for those other instances.
Oh, okay. What occurs when those other instances occur?
For the specified change in tax law provision, if there is a change in tax law that impacts the project by more than a certain baseline threshold defined under the contract, the seller would then have the opportunity to terminate the contract. At that point, there is a negotiation period where parties could renegotiate the contract and try to come to new terms after that specified change in tax law occurs. And if parties were not able to come to agreement, then a termination right would open.
Okay.
And under the extraordinary federal action, that's related to federal permitting and potential delays caused by federal permitting. And the relief there is limited mostly to COD schedule relief, whereby seller would be granted some schedule relief on their target COD if a federal permit was withheld. And then if the permit was withheld for a certain period of time, the seller would then have the opportunity to terminate the contract, and they would owe certain damages for that termination to SPS.
Okay, thank you for that clarification. Okay, those have been answered. Okay, so this question is in reference to your direct testimony at page 26, lines 32 through 35. And you state there, quote, SPS is required to maintain an average annual state of charge each year below 51%. If SPS exceeds the average annual state of charge of 51% by 0.1% upon the conclusion of any year, then SPS is subject to a charge for each 0.1% that the average annual state of charge exceeds 51%, end quote. Can you help me understand how SPS will make a determination? And granted, I did see in the testimony that SPS in other contracts, similar contracts, has not needed to exceed that limit, is a piece of testimony that's there. But what the process is by SPS for making the determination as to when it may need to exceed that average annual state of charge?
My understanding is that we haven't made any sort of analysis or determination of when or how often we expect to exceed that. I will say we have operated batteries in other jurisdictions, and we have not exceeded those values up to this point. Our operations teams are typically aware of whatever those limits are in the contract, and they typically account for such limitation in operations of the battery.
Okay. Then with respect to that, so there's testimony in the record that a 40 to 60% is common, and that aligns with warranties for batteries and what the manufacturers provide. And so given that bandwidth of 40 to 60%, can you explain why SPS has their standard contract at 51% as opposed to 60%, for example, that might allow for greater arbitrage revenues to come out of the use of the battery if it were a higher number?
Yes, we set the limit at 51% as kind of a midpoint of the range that we've seen in negotiations, and the range that we have been the developers have told us is what they're seeing on their warranty and manufacturers agreements. We set it at the midpoint of that range. I think you would expect to see potential price impacts if you were to start to increase that limit. Obviously, as a state of charge increases, that leads to more degradation on the battery resource, more wear and tear on the battery, which can impact operations and maintenance costs. It can lead to more aggressive augmentation schedules. So as you increase that percentage, I think you start to see price impacts associated. So it was a balance of operational flexibility while also trying to maintain cost control on these projects.
Okay, thank you for that. Let's answer. Okay. Sorry, I'm just, this quite often happens where certain things have already been answered, so please bear with me while I just work through the questions that I had laid out. I guess I just have one small question regarding price increases to the contracts, and you provide testimony in your testimony in support of the stipulation on page 9, lines 11 through 17. You state there, quote, "I respectfully disagree with the suggestion that a material term of the LTPPAs could be revised at this time, especially a term as material as the pricing structure of the LTPPA itself. If SPS were to do so, the terms would conflict with requirements of the 2024 all source request for proposals itself and the assumptions on which the bidders were required to base their bids. Therefore, such a change to the contracts could potentially undermine the integrity and fairness of the 2024 RFP." End quote. My curiosity is, a 3% increase to the contracts, do you consider that a material change to the pricing structure of the contracts?
I don't think I can speak to whether that's material or immaterial. When that price increase was presented to SPS, it was a requirement of the seller at that point to continue forward with these projects. And so SPS risked these projects dropping out of the RFP altogether. And an analysis was done internally to determine whether it was prudent to move forward with these 6 contracts with the 3% price increase, or let them fall out of the RFP. And at that time, it was determined to move forward with the contracts.
Okay. Okay, thank you for that. Okay, here's one question. I'm going to refer you to again, you're in the testimony in support of the stipulation at page 14, line 12 through line 15, 3. I mean, page 15, line 3. You address there staff's concerns regarding the use of an annual block average. And you state, quote, "While the annual state of charge limit, SOC limit, will only be measured once per operation year to review compliance with the contractual limit, SPS intends to manage the average annual SOC throughout the year to ensure it remains compliant when the measurement is taken." End quote. My question is, if you're going to do that kind of management, and this is in response to, staff has filed testimony where they suggested in direct testimony that doing a monthly analysis, for example, if SPS is going to manage the average annual SOC throughout the year, why wouldn't that align with doing a more frequent official review as originally suggested by staff in their recommendation for a monthly 12-month rolling average? It seems like if you're doing the review, why not make it an official review? Can you speak to that a little bit?
I can. Having a once a year average is actually more beneficial to SPS customers. It would be likely you would see some seasonal variability in the state of charge, where during certain times of the year you might exceed the 51% limit, and then other parts of the year you wouldn't exceed. And so it allows some flexibility throughout the year to operate the battery as needed, while also ensuring that you can meet the stated state of charge limit at the end of the year.
Okay, thank you for that. That's the extent of my questions. I have no further questions at this time for you, sir. I appreciate it. Thank you very much.
Thank you.
Mr. Larson, Ms. Hardy, do you have any follow-up questions for Mr. Cecil?
No, thank you.
Thank you, Ms. Hardy. Mr. Cecil, thank you so much for taking the time, and you may be excused.
Thank you.
Thank you. Okay, I believe that the next witness on our list here, Ms. Hardy, is Mr. Trowbridge. Is that correct?
That's correct. He should be joining here shortly.
Great. There he is. I'll admit him now. Good morning, Mr. Trowbridge.
Good morning.
Thank you for being with us. We'll have you sworn in by our court reporter, Ms. Gonsalves, and then Ms. Hardy. I believe, Ms. Hardy, you presenting this witness?
Yes, thank you.
Thank you. Okay, go ahead, Ms. Gonsalves.
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Good morning, Mr. Trowbridge.
Good morning.
Can you please state your full name for the record?
My name is Alexander Trowbridge.
By whom are you employed and in what capacity?
I'm employed by Excel Energy Services as Director of Pricing for SPS.
And do you have in front of you direct testimony that you prepared that's marked as SPS Exhibit 10?
I do.
And that document has already been admitted into evidence, so I have no further questions for Mr. Trowbridge. He's available for questions from the hearing examiners.
Thank you, Ms. Hardy. Mr. Getko?
Thank you, Ms. Hardy. Thank you, Mr. Hearing Examiner Schaefer. Good morning, Mr. Trowbridge.
Good morning.
It's been a bit since the early morning community solar meetings yesterday.
Yeah.
I have just a few questions. And the first one relates to your testimony, your direct testimony, your only testimony at page 6, lines 11 through 14.
Okay, I'm there.
And quote, you state, quote, while these LTPPAs are projected to increase customer bills in relation to today's current bills, I recommend that the commission find these impacts to be reasonable, proportionate to the scope of the system expansion, and necessary to provide long-term benefits they deliver to customers and the public. End quote. Then on page 28, lines 9 through 11, you state, quote, SPS expects residential bills to increase by approximately 4.13% by the time all LTPPAs are in service in 2028. This estimate reflects the incremental increase in costs for the LTPPAs. End quote. My question is, given this statement in the first quote of proportionate to the scope of the system expansion, does the increase in bills referred to there account for increased load coming onto the system?
It does reflect increased sales. It may be the way that the bill impacts were prepared. It was kind of a methodology to look at as if this was a separate rider type mechanism. So that is, I took the revenue requirements divided by forecasted sales, and the bill impacts in particular were presenting 2028 being kind of the first full year of revenue requirements associated with the PPAs.
So if it accounts for increased load, if I understood that correctly, then the increase, is it correct to understand that the increase reflects an overall increase in the average cost of resources on the system that results from these batteries? Because if load is taken into account, my head says, okay, increased costs, increased load equivalates across a larger number of ratepayers or a larger number of kilowatt hours, for example, or demand charges charged to a larger rate base. And so therefore, if there's an increase of 4.13% and load is taken into account, then that helps me see that the average cost of the resources in the system are increasing. Can you speak to that? Am I seeing that correctly?
That's accurate. That's what we would expect out of this. And so I don't present that analysis in my testimony. For instance, the average embedded generation costs on the system versus the capacity costs associated with these units. But generally speaking, I think that that's what we're seeing is more expensive resources now versus our existing kind of average system cost.
Okay, thank you for that. Then can I direct you to page 30 of your direct testimony? And you have a table there, AGT-1, average bill impact by class.
Okay, I'm there.
So I see there that the residential class, like we just discussed, goes up by 4.13%. Large municipal and school goes up by 4.21% in these estimates. Setting aside irrigation power service goes up as well. Can you explain to me how to reconcile? No, you answered that one. I'm sorry. You already answered that first question. So elsewhere in testimony in this case, there's a large amount of testimony or numerous locations where it's identified that forecasts for increased load are in large part or a high percentage part due to oil and gas and large load customers that are coming on, that are projected to come onto the system, that SPS is hoping to accommodate coming onto the system. Can you help me understand why, when I look at AGT1, the largest increases are for rate classes? And I'm sorry, I'm not super familiar with the level of load of an irrigation customer, but with residential and large municipal and school, not necessarily being large load, that they have the highest projected percentage change in rates, but they are not, in the testimony in this case, responsible for the expansion of load upon the system.
So generally speaking, when we look at traditional cost allocation, we typically allocate costs on an average embedded basis. So it just looks like everybody on the system will share the cost of those resources. So when we're looking at the cost of generation costs go up. That will be spread across customers. Rates are higher generally for residential customers versus, let's say, industrial customers, like our 115 customers. And that is because of a couple of different reasons, but one of those is residential customers are lower load factor customers. So when we think about the amount of generation that we need to serve them, the price per unit is higher. That just means that the throughput, there's a higher throughput for an industrial customer for 1 megawatt of available generation versus a residential customer, which might be 50%, something like that. So when we just in traditional cost allocation and the way that we allocate, the way that I presented these bill impacts, I used AED 4CP, and that basically it's looking at the class's contribution to class's contribution of use of resources over the 4 summer peaks, etc. So this does not reflect, for instance, rate design or cost allocation that we might introduce in a large load tariff. Maybe to expand on that, which may be a follow-on question, the company is planning on filing a large load tariff, in and around June 30th of this year.
And if that large load tariff were approved, how would that affect what we see here? Just to kind of close the loop on what you're explaining to me in the general.
At a high level, to the extent that we go through and we identify particular load, and we do something that looks a little bit more like a direct cost assignment associated with the cost of these new resources, that would help to insulate the rest of customers from cost increases. But a lot of when we look at the entire MJB portfolio, there are other reasons that we're procuring assets other than growth. We have resource replacement with replacement of the TOLC units. We have significant changes in the planning reserve margins. And so those are other reasons that beyond growth would cause rates to go up. And then broadly, we also see some growth, right, that would pick up incremental costs as well, outside of that handful of, for instance, new load growth customers, new large load growth customers.
Just because I'm a little lost on one piece. This chart, you said you used the AD4CP, and without digging through my notes here, I thought it was gonna be a 4CP, because the suggestion from staff was to consider something more like a 12 period demand allocator, for example, or something of that sort. So this chart was produced with the same demand allocator that you've been using for many years now, in which you proposed in 2579. Is that correct?
That's right.
Okay, there's the easiest way. So, and you basically answered this, but I'm going to ask it in a layman's way for not being an expert like you are. Like, I look at this from the outside, and there's a lot of growth coming onto the system. I think of rate classes like a residential or a large municipal not causing the growth. Of course, you're speaking to these other reasons, replacement of resources and such. And from just kind of a layman's perspective, and I think maybe this is what we see in the public in the newspapers sometimes and such, the idea that, okay, all this growth is largely caused by certain large load customers, or oil and gas, and we see residential rates going up. And if the large load tariff doesn't come in and there isn't that insulation, is it a fair viewpoint that exists of, okay, these classes are shouldering a burden that they haven't caused? And I tried to think of an analogy, and it's like I came up with this crazy analogy of, like, there's 4 families and they have 3 different vehicles that they've gone in on for driving to work, carpooling to work. And depending on how many folks are going to work that day, they take either the small vehicle, the middle, or the large. They're trying to save on gas. And then one of the families has 10 people move into town, and the group has to buy a bus. And the families that didn't have those 10 family members move into town look around and say, well, I didn't cause the need for this bus. And now you want to charge me for the bus? And with that kind of analogy as perspective of why I see that viewpoint out there in society, can you help me understand why it might be appropriate still that those other families have that increase if it were just, an expansion of that need, or whether we're seeing an effect here that maybe could be determined to not be just and reasonable for those rate classes, and hence SPS's interest in this large load tariff?
Yeah, I think maybe I can just kind of talk about broad theory, just a bit about traditional cost allocation and some of the trends that we've seen nationally, especially with this kind of generational growth, demand growth, et cetera. I think historically, when we think about cost allocation, we think about simple administrative methods to go through and allocate costs, and we don't have substantial growth across the system. We have, minor growth. We have population growth. Some commercial growth. It depends on the individual utility. But when we look at cost allocation, we really don't look at each resource, right? Each resource that we procure. It doesn't get individually assigned. It's not, we're not locating a resource just to serve one customer. We're thinking about the overall reliability of the system. Everybody is using the entire system. All of the power generation is being utilized to serve customers. And if we were to, just for instance, if we were to go through and try to create a vintaging of assets to pass to customers, we'd have all sorts of additional complexities, like older units may have higher O&M burdens. There may be more replacement, et cetera, et cetera. So there would be additional complexities in terms of trying to do that. And if you can think of that occurring year after year, decade after decade, after new resources coming on, it becomes beyond the ability to really kind of track that, and it doesn't really represent what's happening on the system. And so that traditional regulatory cost allocation methodology is kind of what we've used. I think there's two things that I see. So in the stipulation, the company and stakeholders have agreed to a stakeholder engagement on cost allocation, class cost allocation. So that's part of our plan, is to go through and explore some of the alternatives. So just in terms of kind of moving forward, that's something that we've agreed to. I think that we have seen, maybe not broadly yet, but we have seen some utilities start to apply alternative cost allocation methodologies that start to look at least who's, essentially who's using generation. So as opposed to just 4 hours of cost allocation, you may be looking at top 500, top 1,000. Some explore an 8760 methodology, right? Looking at all hours of dispatch, what resources are developed. And so we have more information, more computing power. And with our AMI infrastructure, we'll start to see, right, we're still really on the front end, even though we're essentially fully deployed in terms of gathering data of how our customers are using the system and being able to stratify that. We're still kind of on the front end of that data gathering. So that's just kind of the continuum of where we're coming from to probably where we're headed in terms of information and understanding how resources are used and cost allocation in general. And then more so nationally, I think that regulators and others are seeing this generational growth. A lot of it is driven by data center growth, but we're also seeing significant other forms of growth, other industrial expansion. And along with that, with our portfolio, right, we look at a current peak today of 4,500 to 5,500 megawatts. We're adding around 3,300 megawatts of accredited capacity. So this is a generational level shift. And so there are new accommodations coming in, like a large load tariff, to try to isolate, to the extent possible, insulate existing customers, try to identify what are the costs of these new resources, and send a better price signal for the cost of that growth.
That's helpful. I think it answers my question, which would have been this. Well, I might as well just ask it. Of the agreement and the stipulation to explore that alternative allocation structures is partly in response to what I was seeing in this table AGT1, for example, and what I voiced of this larger general societal perspective of we have generational load impacts coming on, and so the old allocation method might be leading to results that certain parties might not think are just and reasonable for rate classes that are not responsible for that generational growth.
And what I would say is, this is illustrative. This is our traditional rate making, and so I didn't attempt to put any kind of unique spin on this. It was just intended to be as kind of straightforward and traditional as possible. In our rate cases in New Mexico, we're continuing to develop tools. Like in our New Mexico FTY, we introduced an EAP, which is an energy assistance program that's targeted to particular, energy challenged homes. Also, traditionally in New Mexico, we have applied gradualism adjustments. So on top of the just mechanics of cost allocation and what we've looked at, on top of that, there are pretty significant adjustments that we've made for affordability, kind of a continuum on affordability and balance between our commercial and residential customers. So there are a lot of tools. Ultimately, this doesn't have to be representative of exactly the way that it's going to turn out. This is just a first level kind of surface exercise of traditional cost allocation and what that might look like.
Okay, thank you for that explanation. With respect to that, and I think I know the answer, but you also haven't applied effects of energy costs and possible arbitrage values that might come from these batteries. That's not included in this table either, is it?
It is not.
Yes. Is that, there's testimony in this case that SPS is at, I think it was 1,000 megawatts if these are approved of batteries on the system. And I imagine that provides a fair amount of arbitrage value depending on what the contracts are for particular ESAs versus others. I imagine that some of those may not allow for certain arbitrage depending on the structure of the contracts. But do you see a value in moving forward in starting to model in arbitrage values into rate impacts for classes? And are there plans for doing that, or are you already doing that? Is it possible? Another open-ended question to learn a little bit here.
So the value of arbitrage, I think that's a good question for Justin Gable, in particular. And I know that the arbitrage value is part of the Encompass modeling and which resources are ultimately chosen. My understanding, and he might be able to confirm that, is that there is, I don't know that negligible is the right term, but it's fairly limited what the arbitrage value is. Because although there is a delta in market value, you also have the element of round trip efficiency, which eats into that potential arbitrage value. It is right, of course, it is, it's essentially close to a zero fuel resource. So if you're comparing it to the marginal cost, versus another resource, there may be an advantage if you think of it that way, as compared to a thermal resource. I think there's an opportunity potentially to expand into energy arbitrage values by class. I think that may, for instance, come into play. To a certain extent, these mechanisms have to be still administratively feasible. But I see an opportunity to continue to modify our fuel recovery resources. And we are looking at a time of use pilot as part of the New Mexico FTY. So we've proposed a pilot there, and I think we'd have to look at kind of cost benefit, those types of things. So I don't know if there's a value to commit to that in particular, but I think it's an interesting topic, and it's certainly important to understand. When we kind of stratify our costs, and we understand those, and we understand the users or benefitters of energy, I think that we have an opportunity to analyze that, at least to some degree.
Okay, thank you for I appreciate you being willing to kind of pontificate with those questions to help me build knowledge and understand a little bit of the detail along with that in this case. I'm looking through my questions just very quickly. That's the extent of questions that I had for you today, Mr. Trowbridge.
Okay.
I
Thank you,
appreciate
Hearing
it.
Examiner Gedko.
Thank you very much.
Thank you, Mr. Trowbridge. Ms. Hardy, do you have any follow-up questions for the witness?
I do not. Thank you.
Thanks, Ms. Hardy. Thank you again, Mr. Trowbridge, for taking the time, and you may be excused.
Thank you.
So I think just in terms of our housekeeping and our witness order, we're waiting for Mr. Gable. He won't be available till after 1. And then we have staff witnesses and possibly Mr. Lee from OPL. So why don't we recess here maybe at 12 or 11:50 and come back at 12:50 if the parties and Hearing Examiner Getco is amenable to that?
That works very well for me to speak first, and let's see how it goes for everybody else.
Does that sound good for everybody? Ms. Gonsalves, does that work for you?
That works for us, for staff. Thank you.
Excellent. Okay, well, thank you so much. We're in recess till 12:50, and thank you everybody for a good morning hearing. Thank you. We'll see each other in about an hour.
Just one
Thanks.
reminder, everybody,
Yes.
a reminder that the YouTube most often stays on over the lunch hour, so
Right.
remember to mute yourselves.
Thanks,
Thank
Hearing
you.
Examiner Getco. Thanks. Take care. Good afternoon, everybody. Are we all here? Let me admit some people, Mr. Larson, Mr. Rushoff, and GBL03. I assume, Ms. Hardy, that's one of your witnesses?
I believe that is, Mr. Gable is on and
Yes.
available.
Right, okay, GBLJ, that looks like Mr. Gable's designation. Excellent. Good afternoon, Mr. Gable. Thanks for being here with us.
Good afternoon, hearing examiner Schaefer.
Okay, before we go on the record, just, for housekeeping purposes, anything the parties want to discuss? Procedurally, if not, we can go ahead and get started with Mr. Gable. Okay, Ms. Hardy, please present your witness.
I'll
One
swear him
question.
in.
And
Just
Mr.
one
Larson will
thing.
be presenting.
Oh,
Great.
I'm sorry to interrupt everybody. I wanted it on the record as opposed to just being a housekeeping. I reviewed my preparation for the hearing over the lunch hour, and I will not have questions for Mr. Lee any longer. The issues that I wanted to discuss have been addressed. I don't see any way that questions will come up for him at this time. And similarly, but with a little bit softer statement, my questions for Mr. Crespin are going to be handled elsewhere, though I see a slightly greater possibility that Mr. Zigich might defer something to Mr. Crespin. But I do not have questions standalone for him at this time. I wanted to update the parties on that.
Your
Thank
Honor,
you, Hearing Examiner Gecko. Mr. McMillan?
Hearings Examiner Schaefer, do you have any questions for Mr. Lee, or should I inform him that he is not needed?
Thank you for asking, Mr. McMillan. No, I do not have any questions for your witness. Thank you.
Okay. Thank you, Your Honor.
Thank you. Okay, Ms. Gonsalves, are you ready to swear the witness?
yes. Please raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Good afternoon, Mr. Gable.
Good afternoon, Mr. Larson.
Can you please state and spell your name for the record?
Yes, my name is Justin L. Gable, Gable.
And what is your role at Southwestern Public Service?
I am the Director of Resource Planning and Bidding.
And do you have before you what's been marked as SPS Exhibit number 5, which is your direct testimony, as well as SPS Exhibit number 6, which is your testimony in support of the unanimous comprehensive stipulation?
I need to grab it out of the box. I just got here. I apologize.
And while he's doing that, Hearing Examiner Schaefer, those exhibits already been admitted into the record, so Mr. Gable is available for Hearing Examiner questions.
Thank you, Mr. Larson.
Appreciate the time. I have Exhibit 5, which is the direct testimony of Justin Gable, and then Exhibit 6, the testimony in support of unanimous comprehensive stipulation by myself.
Excellent. I think that brings it to me. Good afternoon, Mr. Gable.
Good afternoon.
Since you weren't here this morning, I'll introduce myself. My name is Kevin Gedko, and I'm working as a co-hearing examiner with Mr. Schaefer in this matter.
All right, free time.
First, I have a few questions that, based on questions that I asked other witnesses this morning, they were directed to you.
Okay.
And then I'll proceed to a couple questions that I had prepared for you. The first question deals with the accredited capacity ratings for batteries within the Southwest Power Pool.
Mhm.
And in the stipulation, which is Exhibit 13 at page 6. There, I'll read the quote for you. It's an agreement in the stipulation. It says, quote, SPS agrees to perform and provide in the July 2028 required compliance filing in case number 13-00031-UT, a cost benefit analysis that reevaluates whether continued participation with Southwest Power Pool is in the public interest, including an assessment of the Southwest Power Pool's methodology for calculating the accredited capacity of renewable resources and BESS resources, BESS resources. End quote. My question is, are you able to tell us how the processes go at the Southwest Power Pool for setting the accredited capacity of resources? And go ahead.
Yes. So thank you for the question. So ELCC is a methodology that's utilized across the industry. It is for the first time having been implemented in summer 2026 at the Southwest Power Pool, and that methodology applies to wind, solar, and battery storage resources today. The study for ELCC is a way of evaluating a resource's net dependable capacity. And the way they do that is by taking the resource and having a load or having your analysis that ties to your reliability standard. In SPP, that's a 0.1 LOLE, loss of load expectation. That's a standard number across the industry. And as a change, since our IRP process is that SPP has moved to a seasonal resource adequacy construct. So now there's a winter and a summer season, and that LOLE is evaluated on both seasons. So ELCC also has a seasonal component. So these resources are evaluated for that season. And the ELCC analysis is by taking that 0.1 value and with and without the resource, how much additional load can the system handle with the addition of the resource? And that becomes its net dependable capacity. So it's an analysis that will ultimately be for each individual resource. Today, that study hasn't been done. These are our best estimates with the information that's provided. Generally, ELCC declines as a resource type increases its penetration into that system. So as we see more batteries or more wind or more solar on the system, each additional megawatt of those resource types is less effective than the last megawatt. So there is an interplay between the resource types, and SPP has provided studies on their ELCC generally. Did I lose you? Are you still there? Okay.
You went still for a minute, but I could still hear you. It has Miss Gonzalez, were you able to hear Mr. Gable the entire time?
Okay. Just want to make sure.
Thank
you. So that's those resource types. Those have been studied across the SPP system, and different levels of penetration of those types of technologies have been studied as well. So we get what we call a declining ELCC curve for these resources. And we took that information and we applied it to our resource solicitation so that we modeled what it would look like to have the increasing penetration of these resource types on our system. Ultimately, these are estimates today. They're our best estimates, and ultimately, these resources will have to be studied once they are in service. So today, these are our best estimates for where that ELCC accreditation is expected to be, and it's based partially on the expected level of penetration of those technology types on the SPP, the Southwest Power Pool system as a whole, not just specifically to SPS.
Okay, thank you for that. A couple follow-ups on it. Is the study process a hard science, or is there a bit of an art to it?
So with any kind of study, especially with generic resources, SPP has been looking at their system and trying to understand this. Every year, the requirements of the study or the rules and parameters or the settings for which that study is completed are reviewed by SPP, and specifically the Supply Adequacy Working Group, which I'm a voting member of. They call that the SOG, SPP SOG. So these ELCC studies are reviewed annually, and there can be changes between years on the parameters with which are adjusted to get the accreditation. In fact, between when we provided our original accreditations or accreditation assumptions, and now SPP has provided a different study, and they did change some of those parameters. One of those being the dispatch of demand response and hydroelectric generating units across the Southwest Power Pool. And they did see an effect specifically to batteries and their accreditation because of the change in how they ordered the dispatch of those resources in the ELCC models they produced.
Okay, interesting. There's testimony in this case regarding the benefits. I think there's testimony in this case. If not, maybe there's general knowledge in the world that batteries and their location on SPS's system provide benefits in that a reduction in need to use transmission capacity, the ability to have a localized benefit that my understanding is the batteries are located in certain locations because their benefits can be maximized by being located in those locations on SPS's system. Is that a generally correct understanding of that there's an analysis of that location of the batteries by SPS?
Excuse me, I'm sorry about that. I didn't mean to talk over you. Do you mind if I expand on it a little bit?
Please do.
In general, what I would say in this evaluation, SPS in this evaluation found a lot of value in these specific batteries because they were co-located at existing locations. That value is identified as avoiding a transmission network upgrade costs. So if you have a new standalone battery and you were to put that into the DICEs, which was a requirement for new generation resources with the new DICEs as part of the 24 RFP, you would have to put that into the DICEs queue, and it would be studied by SPP to identify network upgrade costs, both to connect it and for general network upgrade costs across the system. By co-locating and limiting the batteries to operating behind the POI of an existing resource, those network upgrade costs are avoided. So that's the value of the location of these specific resources. I would say in general, you can find value locationally. The Encompass model does do the Encompass model. I'll back up just a second. The Encompass model is the production costing and expansion model that we utilize to evaluate. That model is zonal based, so it is not what we call a nodal based analysis, which we identifying the LNP differentials more localized. So we did not do that level of analysis that you're talking about, where you can see like the specific locational value at that level of detail. And that level of detail is really a more near-term analysis and doesn't really talk about like long-term effects. And the value of the evaluation we did is over the full 20-year optimization period. And there has to be certain assumptions about what the transmission system will look like to do a nodal analysis that may not exist in the future.
Okay. That's helpful because where my questions are going to is we've seen testimony in this case where the reserve margin of the winter reserve margin is I'm misstating it, 36% at this point. Is that correct?
At this point, yeah, I'm sorry. Go ahead.
In 2029 goes to 38%, correct? On Southwest Power Pool?
That's where it's expected to go. There could be some changes. In fact, we've seen there's a new strategy for how they're going to be setting the PRM between like 1, 3, and 5, 7 years. And those numbers will the PRM can potentially change in those further out years. So it is subject to change, but yes, today it is 36%.
And so we saw some testimony from staff and direct testimony that, highlighted the low estimation for the BESS during winter as providing, accredited capacity of something like 16%, if I remember correctly. And I'm just curious, and it's these zonal issues of, if you're on a voting board at Southwest Power Pool with respect to how this accreditation goes, and SPS is one of the most southerly members of the Southwest Power Pool, is there an ability for you, for your company, to advocate based upon facts and science for an increased accredited capacity rating for the batteries that are on SPS's system, given the environmental nature of SPS's territory and the fact that, they're co-located, et cetera, et cetera. I'm wondering if there's avenues for advocacy to, maximize the accredited benefits of these resources on your system in relation to the Southwest Power Pool.
So yes, we do have the ability to influence the information. What I will say is that a lot of we've done analysis on the system during winter time, and although there is low accreditation value right now that we're estimating for these batteries, what we see is that our analysis supports that lower accreditation value. You can think of it as like in an extreme weather event, or in other times, there's a couple of things I'd like to point out. An extreme weather event, once you've exhausted the 4 hours of the battery, it does have to be charged. And so it does, if you have a multi-hour or even multi-day weather event, that load that becomes an additional load, not necessarily a source of megawatt hours to inject into the system. So, it has been said before, that these are really moving megawatt hours around. They're not generating megawatt hours. A couple of other things that I would just point out is there are some critical components about the current load on the system that affects ELCC. So for SPS, with our high load factors of our high industrial and commercial bases, we see a very steady load factor and a very high load factor. And so, when you're talking about the value of a battery on an accredited basis, the peak is not as peaky on the SPS system as it can be on other systems in New Mexico. So the fact that it's not as peaky can also affect the ability to account ELCC accreditation for those resource types. So if your peak is generally, 2 hours, and when I say peak, it's not necessarily just a value, it's a range. But as you look over the peak and that value, you need that battery to operate over 4 hours. So after that 4 hour, you're talking about kind of stacking up batteries, not necessarily on top of each other, but kind of spreading them out. And as you're spreading them out, you don't get that same 1,000 megawatts on top of each other. You might get 500 megawatts. If you can kind of, I might be explaining this a little bit poorly, but the 4 hour block of a peak, if it is a larger peak than 4 hours, if you're trying to rely on batteries, the total volume of batteries can't all be stacked on top of each other in that 4 hours. You would have to spread out the utilization of those batteries across the entire peak, kind of like a peak shaving exercise. That the problem with the SPS system, it's not really a problem, it's just a feature, or not a feature, it's a description of our system, is that the load factors are so high that we don't see a lot of peak and valley that would ultimately drive a higher accreditation value for batteries.
Interesting. Okay, thank you. Thank you for the explanation. Okay, that covers my questions there. Thank you very much. I'm going to move on to Okay, I asked a question this morning to Miss Lees in reference to her testimony in support of the stipulation, and I'm just going to quote it for you. It's just a couple sentences.
Okay.
Well, P&M has certain 20-year best LT PPAs that use a different variable pricing structure. SPS is not aware of the specific reasons for P&M's choice of best LT PPA contract structure. SPS made a reasonable choice to limit the best LT PPA terms when it issued the 2024 RFP, although variable pricing option was allowed in SPS's 2025 RFP. And end quote. My understanding from elsewhere in testimony is that the variable pricing structure is viable and perhaps more appropriate when the BESS are co-located with an energy generating resource and the contracts are established at the same time for the energy generating resource and the BESS. Is that a fair understanding?
In general, I would say that hybrid projects potentially have the ability to do that. To roll their capacity portion of the payment into the energy payment. Yes.
And I learned this morning that for the 2025 RFP, there isn't a restriction for bids of variable pricing structure to only what you've now termed hybrid projects. So then I asked this question of, are you at a point in the 2025 RFP to know whether you're receiving bids for variable pricing structure for non-hybrid battery energy storage systems?
Let me make sure I understand your question. You're asking about the 25 RFP, and I will make the point that I don't want to comment on specific bids, but I think that your question is focused on the idea of a standalone battery, and a standalone battery doesn't currently have the ability to be able to roll a capacity payment into an energy payment because the energy is not a part of that contract. There is only the capacity component of the contract. So yes, hybrid projects or batteries are being co-located with an existing PPA. There's opportunity to either adjust the current PPA or provide some kind of process to move to a variable energy payment. But a standalone battery does not currently have that ability, at least from my current understanding of the issue.
Okay. Then that leads to one other question for me of if there's an ability to adjust the existing PPA of an energy resource to be able to co-locate a battery, which is what I understood you to be saying with respect to the 2025 RFP. How do I understand the testimony in the current case where, and I can go find it, but generally the testimony has been given that due to the timing of the contracts and the initiation time points of the existing energy resources, it was not an option for SPS to consider variable pricing structure for the 6 BESS LTPPAs that are up for approval in this current docket. Could you explain what I think, please?
I think I understand your question. We might have to have a little bit of dialogue back and forth, make sure that I'm getting at the heart of your question. But I would say that the 24 RFP, we did not have that as a component in a description of a possibility in the 24 RFP. And so to backcast and to make changes, I don't know that I could agree that would be a fair competitive practice to be changing the parameters with which these PPAs could provide their batteries into the RFP. That information wasn't available to other bidders at the time of bidding. It might have ultimately changed what bids we received. So I don't think it's fair to backcast our evolution of our requirements in the RFPs to previous selections. I also think that I saw that you made a point about the timing component, about the different PPA lengths. I do think that is a component. I would probably have to defer to Levi to have a little bit more conversation on exactly what that is, if there's an ability to adjust the PPA. But what I would say is that in the 24 RFP, the only option for a battery was to provide as a capacity payment. So I think it might be a moot point for the 24 RFP.
What changed then between the 2024 RFP and the 2025 RFP to make SPS update the RFP to allow for the variable pricing structure in 2025, whereas you hadn't in 2024?
I hear your question. I appreciate it. I think that's what I would characterize it as. This is an evolution of our structure. It's a better understanding of it. The specifics around it, I am not necessarily in treasury. I think that we could probably take that back and maybe get a better answer. But developing these RFPs, I generally design these RFPs, but it does take a team effort, and I'm not necessarily an expert on every part of like the PPE contracts and things like that. So I might have to defer. I apologize.
And it would be a deferral to witnesses that we don't currently have in this case, because they would be in treasury, correct?
I might need a little bit of help on identifying the appropriate witness. I mean, if somebody could speak to that in this current case, but I don't know that I could answer that question right now. I apologize.
Okay. Then I'm going to move on to my next question. Thank you for that discussion. And I'm sorry, I'm between questions between witnesses, so sometimes this takes me a minute. So
That's okay. I understand.
okay. So this question has to deal with the Encompass modeling and discussions this morning. I had discussions with Miss Lees with respect to the effects of, or the projected effect of imputed debt on credit metrics for SPS. And, as well as certain mitigation measures taken by SPS with respect to the effects of the imputed debt. And my questions started to center on whether SPS has done a numerical analysis of what the effects on rates, on overall costs for SPS, and therefore rates, that would result from the change in credit metrics due to that imputed debt. There's a $640 million estimate for increase in imputed debt. And but there aren't specifics numerically that I could locate in the application or testimony with respect to what the actual effects would be numerically on revenue requirements, rates, etc. And it was raised to ask with you whether Encompass modeling may take these effects into account, whether Encompass accounts for those sorts of effects due to the imputed debt that comes from PPAs inevitably on your system. Can you speak to that?
Yes. So no, the Encompass model does not model the imputed debt or impact. I would say is our approach was to make sure that we had a design up front to limit its impact to the company. So that's why we had the 15-year PPA limit for batteries. We tried to avoid and mitigate that risk up front. We didn't necessarily model that risk though. But like I said, we're also evolving. We evolved into our 25 RFP, the option for variable payments and energy payments. So there's a few things that we have identified to be able to help further mitigate that risk. But no, it is not modeled in Compass.
Okay. All right, thank you. My next question, you can thank Mr. Cecil for passing it to you.
I'm sure I'll let him know. Give him a thank you.
So my question was revolved around the 3% increase that's covered in the testimony with respect to the LTPPAs that are under consideration. And
Yes.
that after bids were selected, there was a 3% increase. And my question was, and Mr. Cecil referred to an underlying belief that despite the price increase, those projects were still the right choice. My question is, did SPS go back to other bidders, go back to look at the bids to determine whether other bids that had not been selected would need a 3% increase or perhaps would not? Was there a reevaluation of whether there were bids that were close enough to the selected bids that now have a 3% increase that it would have merited taking a close look at whether they were going to be competitive with what was selected?
Yes, it's a very interesting question. I would like to describe these bids and then provide some more anecdotal information because I don't have the bid tables in front of me about what else was bid in. But these bids, they represent the earliest capacity that could come on SPS's system. So we have immediate customer needs today, and there is no other bid that could come in at the time that these projects could come in. Part of the reason that is because they are surplus at existing sites. So that one major barrier on the timescale component is the DICES queue currently. And by being a surplus project, these projects were able to come on sooner than other battery projects that did have to go through the DICES. And so they have a later COD date. When I say COD, I mean commercial operation date. Apologize for the acronym. So that is okay, go ahead.
Can you also just really quickly give us the acronym for DICES? I think I recall it, but it would probably be good to have on the record.
Yes, we use that acronym so much, but I think it's, let me try. Definitive, oh my gosh. Definitive Integrated System Impact Study. Got it.
Okay.
All right.
Sorry, I interrupted your train of thought there.
No, that's okay. No, it's okay. I'm a little shocked that I got it. It's such a long acronym, and we use it so often that you kind of forget the meanings of the acronyms, or not the meanings of it, but like what the actual words represent. So apologize. Yeah. So the earlier these projects came in, that is a definite advantage to these projects, and there is no other projects in the bid pool that can provide the capacity that early and connect customers that are actively seeking to connect today. Additionally, because they're surplus projects, we already talked about the COD, but it also represents an avoided cost of the TNUs and transmission network upgrade costs. So that is another component here where the pricing of these projects, so they were able to come in sooner, and at the prices that they were coming in at. These are the projects that best met the system needs, even with the potential for price increases.
Okay. Are you able in the RFP process to take into account the mitigation of transmission upgrade costs, is just generally, or do you have to look at the projects just on their own when you're in the actual selection process of the bids in that iterative process?
I might need a little bit more information. I could speak anecdotally a little bit about the difference between the 24 RFP and the 25 RFP, because one of the things that was raised when we were going to be issuing the 25 RFP was the DICES queue. And in the 24, we did require the phase 2 study to be completed to enter into the RFP. That helps establish firm, operation dates. It also helps to firm up the bid pricing. In the 25 RFP, we did lower it to the phase 1 requirement, not the phase 2. And what we saw is that the network upgrade costs that we're seeing from phase 1 are drastically different, and will, because at phase 1, there are at least two other opportunities for those prices to change. So as we are going in this 25 RFP evaluation, we have the DICES phase 1 numbers that we're doing the evaluation on. There's also going to be a phase 2 reevaluation of those numbers, and then potentially a restudy. So as we are going through time, these DICES identified network upgrade costs can change if you don't consider them, or projects that are through that process already. So it is a thing that needs to be considered, especially comparing a surplus project versus a DICES project, on if how far along are they in that process, and how firm are those network upgrade costs identified. Because the surplus projects, we know with relative certainty what those network upgrade costs are going to be related to connecting into the actual substation.
Do you try to turn that analysis into a numerical point structure, or is that a piece of the RFP process where you're looking at bids you get and saying, okay, this one, it's adherent DICES, like these are competitive pricing wise, or but this one's got that advantage of it's gone through phase 2, or is that something that you put into numbers in a bid evaluation? And I don't need a ton of detail. I'm going to move on to the next questions very soon, but you're piquing my curiosity on a couple elements.
No, that's fine. I'm glad we're having the conversation. I will say that it would probably be more informative to look back at the IRP process, because the 25 RFP, it's under evaluation. There's a lot that we can't talk about, but the 2023 IRP, it does have a lot of context around transmission network upgrade adders. We call TRX adders. In those, in that 23 IRP, we made certain assumptions about what would receive a transmission adder, what technology types, which ones wouldn't, what level of transmission network cost it would be. I think in the 23 IRP, we had modeled transmission adders for wind and solar projects at $400 per kW and $600 per kW as a range. So to provide some kind of understanding about how these transmission costs can impact resource suggestions by the Encompass model. So I think that report would be informative for that discussion, more so than what we're talking about in the 25 RFP evaluation right now.
And that report would go into the construction of the RFP to try to build an RFP that would optimize according to what you saw in that IRP, correct?
Yes, the IRP develops a statement of need for which we are issuing these RFPs.
Okay. All right. Thank you for that. All right. Now moving on. This is covered. Good. There was a discussion that I had with Mr. Trowbridge, and also it's generally within the application regarding projected arbitrage values, and your testimony in support of the stipulation, Exhibit 6 at page 8, lines 5 through 7. I'll just read it. It's only one sentence. Quote, SPS did not rely on any specific numerical arbitrage revenue values for planning, rate making, or contract evaluation purposes. End quote. And there was some discussion of whether those values were negligible or not. I believe that might have been a word that was used, but wasn't, Mr. Trowbridge didn't think it was perfectly aligned with his sentiment. But my question is, is there an ability, do you see an ability to, and a value, both an ability and a value in actually doing it, if there is an ability to start to incorporate those arbitrage values planning? Because my understanding is currently that is not incorporated.
Yes. I kind of want to build up a little bit on this conversation and talk a little bit about the Encompass model. So the Encompass model, its first step is an expansion model to expand and develop new resources for SPS, and then it is a production cost analysis. Understanding arbitrage value and making a selection on that is not within the parameters inside of Encompass. It is trying to optimize on the least cost set of resources. So implicitly, it's trying to reduce the cost to operate the system and select the resources that are the most efficient, not necessarily to maximize revenue. The battery arbitrage analysis, though, does utilize the hourly dispatch files from Encompass, so the outputs. And we did the battery arbitrage analysis. That is a descriptive analysis of what is happening as an arbitrage component of these batteries. So the model is trying to solve to reduce the amount of cost on the system, and this analysis is more descriptive. I would also say that it's not necessarily fully encompassing of the value of the batteries. And the reason I say that is that we mentioned it's an hourly dispatch. The model is modeling the system on every hour, but there are benefits for lithium-ion batteries on a sub-hourly look. So, and that's not something that we're capturing here, but there's value in there's value to these resources in being able to quickly discharge a load. And specifically, you can just think about solar. Solar has a potential impact from clouds or anything like that. Dips in production, very quick dips in production, and then ramps back up. The ability for lithium ion is be able to kind of level out those kinds of issues with like a technology like solar, and that's not necessarily captured on an hour by hour basis. That's although it's a lot of granular detail. I mean, it's a full 8,760 hours a year over 20 years.
I'm sorry, you got to repeat that. I'm sorry.
Sorry
It's
about
a lot
that.
of granular detail.
It's a lot of the full 8,760 over 20 years is a lot of detail, and it makes the least cost solution based upon that. But there is value to even looking at these batteries at a sub-hourly dispatch. That is not something that Encompass is capable of really doing on the kind of 20-year planning horizon that we're talking about. But I do think that there's value here, and the analysis we did was to provide a very high-level general understanding of the value of this type of parameter of the batteries.
So in the expansion modeling stage, did I understand correctly? It simply can't be taken into account. Is that correct? A simple restatement.
I don't think that you could capture this on the expansion set because you're not looking at the full, even hourly dispatch. You're looking at like peaks and off-peak hours to make the resource elections, and then you move to a production cost setup. So that's why we run multiple different portfolios and compare the production cost runs against each other to see the differential between their net present values to understand the full production cost differences, not necessarily looking at the expansion runs net present value differences.
Okay. And then in the production cost modeling, I only got lost on one piece, probably more, but this is what stuck. You made a statement of, it's interested in the least cost resources, not the, maximum revenue, I think you said. And I see those as kind of two sides of the same coin, in that a battery becomes a lower cost due to the revenue in arbitrage that it can facilitate.
Mhm.
Can you explain that a little bit, why you saw a distinct difference between what it least cost resource versus maximizing revenue? There must be something I'm missing there.
Let's see. I might think about the model as having, or looking at the model as having perfect foresight. It's looking out and seeing what is coming up and can appropriately dispatch these resources and making sure that it's making the optimal selection for. Did I lose you again? I think I might have lost you.
I can hear you. I think we can all hear you. Your video has just stopped.
Okay, sorry about that. But so I understand the sentiment about, well, how is it not maximizing revenue? I think that I could understand the sentiment, but I would say that the model has been characterized as least cost selection, and I might need to have a little bit more time to put together a more eloquent answer to be able to distinguish the two between maximizing revenue and least cost. But I know that the model is designed to be a solution for least cost, and I'm at this moment I'm struggling to think of the counterfactual to indicate how it would be a maximizing revenue model.
Yeah. Okay. I could think of situations where you maximize revenue, but you increase costs in certain ways, and so it's a different analysis. And that's plenty. I appreciate you feathering it out for me a little bit.
Well, I appreciate the opportunity to talk about it. It's always fun to talk about it. I get to do this every day, and it's sometimes you get lost in the computer sometimes, and it's nice to get to talk to somebody about it.
Everybody else is probably hoping we stop talking pretty soon. Let's see what my next question is. I don't have that many. Okay, this is my last little block of questions, and it's with respect to the charging of these vests. And so at page 9 of your testimony in support of the stipulation, going over to page 10, you state, quote, SPS expects best charging and discharging intervals to be determined primarily through the Southwest Power Pool integrated market solution, which is based on economic clearing of submitted market offers of the MSR, supplemented as needed by self-scheduled charging or discharging. Then further along on page 10 and into page 11, you give a description of the ability to understand through meters when energy is being provided from a co-located resource as opposed to coming from the grid, for example. And that's page 10, line 9 through page 11, line 5. So my question is this, I see from reading the testimony that you can distinguish where the energy comes from with the use of the meters. But what I'm not clear on is the ability to supplement is needed by self-scheduled charging or discharging, and how that metering information is used to determine when you're using the marketplace or you're using a supplement of as needed by self-scheduled charging or discharging. I would have understood with my lack of full knowledge that it would always be submitted into the marketplace, given the relationship between SPS and SPP. So can you explain to me a little bit there of how SPS goes about making that determination? And I do apologize. I've just been informed that I think it's my interconnection here at my office building that's a little bit unstable for everybody.
Yes. Yeah, the video is coming back and forth, but we can hear you just fine. So, I think the question was, can I explain how it's offered fully into the market or self-scheduled charging or discharging?
Yes, that's a good shortening of the question. Yep.
Okay. Yeah, I think that right here we're providing the best understanding. I would say that like the Encompass model is not necessarily making that distinction, and that's what the resource selection. So this is just providing some more granularity on how that information works. But the Encompass model is a much more simplified expectation of how this modeling would work. In general, that's a charge at low cost and discharge at higher pricing. That's the general pattern of how we would expect the batteries to operate inside the marketplace and how it is represented in Encompass. Specific market mechanisms on exactly how this works is probably a level of detail that I can't provide much more than I have got right here. I think we've provided just a hair more detail just to kind of give some more context to how it might be different in the market as compared to Encompass model, but it's the same general philosophy between the two.
So you're focusing on the difference there between what our knowledge level is versus Encompass. My question is a little bit more basic than that, I think, which is just, are you able to explain to me SPS's ability to choose operationally when you want to do self-scheduled charging or discharging as opposed to operating through the Southwest Power Pool integrated market solution?
I think that I might need to take that back and provide and get some more information on exactly how that works.
Okay. And you may not have this answer. Is it an incorrect understanding on my part that given the requirements of the Southwest Power Pool, SPS is required to schedule its resources through the marketplace? Do you know the answer to that?
I think I might need, can you maybe rephrase your question just a little bit? I apologize.
I just had an understanding from just kind of general knowledge, which is inadequate, of Southwest Power Pool and the way that power markets work is that there's a requirement to commit certain resources to the marketplace. And then based upon those commitments, the market is smart enough to determine which of those resources are selected and which aren't based on the marginal cost of those resources. And I wasn't aware of an ability and maybe just the wording of your testimony, but to schedule charging or discharging as a process that is separate from integration with the marketplace. I always thought scheduling was done hand in hand with scheduling into the marketplace or discharging based upon selection by the marketplace, given your bid into the marketplace.
Yeah, I understand your question. I'm afraid that I'm not going to be able to answer it in much more detail at this time. I'm sure we can get you some more information, but I apologize.
Okay. Thank you. Thank you very much. That is the last question that I had for you. and I appreciate everybody, well, you in particular and everybody else for allowing me to ask these questions and have this discussion. Thank you.
No, I appreciate the opportunity hearing Examiner Gitko.
Thank you, Mr. Gable. Mr. Larson, are there any follow-up questions on, excuse me, on your behalf?
No, hearing examiner Schaefer, no follow-up questions.
Thank you. Also, I wish to express my thanks. Mr. Gable, thank you for taking the time, and you may be excused.
Thank you, Hearing Examiner Schaefer. I appreciate the time.
Thanks so much. Okay, so I think we have reached the end of SPS witnesses. Is that correct, Ms. Hardy?
Yes,
That's
thank
correct.
you. Yes.
Great. So, Ms. Amer, I believe unless there's any issue, we can proceed with Mr. Zigich.
Thank you, hearing examiner Schaefer. I know that Mr. Zigich was going to join the Zoom and right now.
I just admitted him. Yes, he should be joining momentarily.
Can I interrupt and just take 1 minute to step away and walk down the hall? I know that our IT staff is in my building today, and I just want to make them aware that I have a consistently network bandwidth.
Sure, slow. Yes,
I'll
well
be
taken. Well taken, hearing examiner Gecko. Let's just take a let's do our 10-minute recess now and allow hearing examiner Gecko to consult with IT, and we'll go back on the record in 10 minutes at 1:57. Thank you, everybody.
Thank you.
Ms. Hardy, Mr. Larson, Ms. Amer, are you there with us?
Yes.
Great. There you are, Mr. Larson. Ms. Amer,
Yes.
thank you for being with us. Thanks, everybody. I think we got the matter resolved, so appreciate the patience. I believe we're ready for Mr. Zigich. Ms. Gonsalves, are you ready to swear the witness?
Absolutely. Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Ms. Amer?
Yes. Good afternoon, Mr. Zigich. Could you please state your full name for the record?
Darren K. Zigich
Thank you. And where and are you employed?
with the New Mexico Public Regulation Commission as an engineer in the Engineering Bureau, Utility Division, sorry.
Yes. Um, do you have a copy of Exhibit 3, which is Staff Exhibit number 3, direct testimony of Darren Zigich, and Staff Exhibit number 1, testimony of Darren Zigich in support of the uncontested stipulation?
Yes, I do.
Thank you. Since these exhibits were already admitted into evidence, I have no further questions for the witness.
Thank you, Ms. Amer. I believe hearing examiner Getko has a few questions for Mr. Zigich, so please proceed.
Thank you, Mr. Hearing Examiner. Good afternoon, Mr. Zigich.
Hello, hearing examiner Getko. Nice to see you in the hearing examiner's chair.
I'll try to
Welcome.
do my best. Thank you. Thank you. Yeah, I have a few questions. I'm going to start with Staff Exhibit 1, which is your testimony in support of the stipulation. At page 8, line 11, going on to page 9, line 9.
Okay.
And there's a question and answer there where the question asks, how have staff's concerns regarding the need to define the recovery method of the potential penalties been addressed by the stipulation? And those penalties refer to increased charges that may result from usage of the battery beyond a 51% level. And your answer states the stipulation generally covers cost recovery of capacity charges, but does not specifically speak to penalties. Based upon my further review of the penalties, which SPS refers to as adjustments, I acknowledge now that they can act as both a credit or a debit, and that they are limited in scope and value. For this reason, staff believes the issue is better suited for a thorough assessment in the current or future rate case, and thus was not made a condition of the stipulation. Staff does not believe this issue can be adequately addressed in isolation in this stipulation, end quote. My question, and based on your review of the record as well as testimony provided today in this hearing, do you understand that the commission in a rate case could make the determination of whether to allow those any increased costs due to penalties or adjustments? Could the commission deny those being assigned to ratepayers in a rate case?
Well, that was my understanding. Now, the testimony today of Ms. Lee's kind of brought some of that into question because we're approving the contract as written, and if there's small fluctuations in the cost due to the contract requirements, can you really challenge that in a future rate case? Again, it's not clear to me, at least, exactly how those adjustments would come through base rates unless those adjustments go into the fuel clause, but I don't think that's what these are adjustments to the capacity charge. from my understanding. So those are in base rates. So would they just adjust those over, keep track of those and adjust it in the next rate case if there's an overage or a shortage or maybe it all works out in the future. What is really the main thing is that the scale of those adjustments seem to be fairly minor. Unless it's just blatant disregard for the limits. And I want to clarify that it's not just the state of charge. There's an annual throughput limit, which is basically that one charge discharge per day over a year. There's the state of charge, but then there's also adjustments that are against, well, not against, but that would be imposed on the seller for availability, lack of, if the battery's just not available when they call it up, there's penalties to the seller. So that works as a credit. So maybe over time with the credits and the debits, it's all a wash or it's in the noise of the costs anyways. So it's not something that is highly concerning to us right now. But without actual data, of operations, it's hard to assess that. And it's something that's going to have to be looked at in the future, and maybe some sort of a tracking mechanism for that is warranted given the newness of these types of contracts. Frankly, this case has kind of opened up questions about existing contracts with other utilities that have more of a variable cost that are in base rates and how those are being tracked. So it's not just an SPS thing. I think that's something that we're going to have. It's a new world with some of these battery storage contracts and just the flexibility that they provide and the variability that they do have. It's not just a piece of equipment that has a fuel that goes into it. It's kind of like variable O&M too. It's those types of things, but it's just a question we had and how that would be recovered. But I don't think the scale of it is too big of a concern at this point, unless we have more evidence.
Okay, I appreciate that thorough discussion of it. I had a couple follow-up questions, and I think you've already answered them. I'm reviewing them quickly here. Okay, yep, that is taken care of. Thank you. Let me see my next questions. Okay. So with respect to the state of charge in your testimony in support of the stipulation at page 12, lines 17 through 21, there's a question and answer. And the question is, explain whether and how staff's concerns regarding energy throughput limitations and average SOC ceilings have been addressed by the stipulation. The answer states, quote, the stipulation does not specifically address this issue. This is because the signatories are accepting the SOC originally presented by SPS in the application, and as further explained by SPS in detail in its response to staff's discovery. End quote. In your direct testimony, you had stated on page 11 that SPS provides no analysis demonstrating why this balance is optimal or prudent. If a lower cost resource is constrained to the point that it delivers limited capacity value due to a self-imposed SOC restriction, it may be appropriate for the commission to direct SPS to reevaluate its standard limit in future procurements, end quote. I had a discussion with Mr. Gable just a little bit ago. It may have been with Mr. Cecil, I'm sorry, but regarding the 51% and that being a middle ground between warranty values that are generally between 40 and 60%. Your testimony here explains that it's been accepted by the signatories, but it doesn't update your opinion on whether you think that 51% should be accepted moving forward, whether you still believe analysis should be performed with respect to that number. And so I'd just like to ask you whether you believe more analysis should be done in the future. Are you comfortable with the answers that you've heard today I don't want to do a multi-part question. First, do you believe that additional analysis should be done in the future to assess that 51% level?
Yeah, and I think there's a number of issues with all of these contracts, and like the witnesses today said, this is kind of an evolving, they've been changing it as they go. The 24 RFP looks different than the 25 RFP. P&M has done the same thing. If you look at I have 3 cases that have recently put in a lot of storage over the last few years, and every one of those long-term contracts has modified over the years. So this is definitely an evolving technology, evolving use case, evolving contracts. And, we would certainly welcome some sort of a commission docket to look into these, because the costs of these are not insignificant. And if El Paso starts rolling them out, and SPS is certainly rolling out a lot of these, I think it's maybe ripe to start looking at, how do we contract storage in the future? What are best practices? What is good and bad? Like I said, I think P&M did start out with a low state of charge, and now in their latest contracts, they're up to 75% state of charge. But it's a different, you've got an RTO, utility in a market, you have one that's not in a RTO. So the parameters are different for each utility. P&M definitely needs those resources to be available and charged for when the sun goes down, because they are so solar heavy. They need all the resources to load up. They need the batteries to load up during the day when the solar is ripe, and then they need them when the sun goes down, because they lose 2,000 megawatts in a flash. So they cannot. I think 75% basically gives you more flexibility, because it's a number or below. And so then the higher you can go with that number, it benefits your operational flexibility. If that's the goal with these capacity resources, is the primary goal is not arbitrage. The primary goal is resource adequacy. So in my mind, you would want as big a number as possible at some cost, of course. Now, did P&M pay a premium for 75%? They may have, and that's a good question to ask. But if you have a window of 40 to 60 and the price is pretty much equivalent in that 40 to 60, then I would choose 60 instead of 51, just, without any considering other things. You'd want as much flexibility operationally as you could possibly have. I'm not saying it's right or wrong. It's just something that may be ripe for discussion, since we're looking at hundreds of millions of dollars, billions of dollars of these products coming online here and in the future. And we certainly don't have the answers, and it may be different depending on what your footprint is and what your your customer base is and everything else. But that's just kind of an observation, is that we're seeing some fairly significant differences, and the utilities are 100 miles apart. Why is a battery in Roswell so much different than a battery in Albuquerque?
Would, thank you. That's very helpful information. As a follow-up, would you benefit from seeing a more robust analysis of the SOC valuation that is chosen for a contract when SPS applies for approval of a capacity resource such as the BESS? And I proffer that question with an awareness that there's an active RFP out there that's been discussed today. And could you speak to what would be beneficial to your analysis in case the commission isn't able to do a docket for a general analysis? What would help you provide optimal evaluation and testimony if you were faced with something analogous to what we're facing today?
Yeah, well, thanks for that question. I guess a cost comparison would be helpful. I mean, because again, the higher number presumably provides much, more flexibility, more operational flexibility. If I have 60 or below, that's better than 51 or below. I've got more headspace to operate that battery. If that is given at no additional charge, then why wouldn't I or a utility take that? If there's a cost for that, then of course that has to be balanced. But I think the 51% was in their standard contract language. And so I don't know if there was any negotiation between that 40 and 60% window. Now we'll assume maybe over 60% there is a premium to be paid. Maybe PNM did pay that because of their specific need. But if that 40 to 60 window is gratis, then I'm not sure why a utility would not take the upper number. And so that's we just didn't get a good explanation as to why 51, except for it's down the middle. Like it's a balance between the seller and the utility, whereas we're trying to fight for the customer's best benefit, and the customer's best benefit is probably, well, and even the utility's best benefit is more operational flexibility. So if that comes at no cost, then we should be aware of that.
Thank you. And I'm recalling testimony in this case of, I don't remember who gives it, but a witness speaking to the 2026 IRP process and being in the middle of it right now. Do you think that would provide an opportunity for staff to ask questions and to have a dialogue with SPS with respect to a cost benefit analysis for the structuring of these BESS contracts and the RFPs that limit the contracts that can be made?
Yeah, generally they don't get into that much detail. We do have a condition that we asked for in the stipulation regarding the IRP, but that was a different issue, and more on long lead time items, because the problem we've seen with this case and with the previous resource case was the short time frame that they have to get these resources on the system, and how that limits their ability. They're basically, it limits their selection. unfortunately. And so what we're pushing for in the 2026 IRP is more of a longer term look, so that they're doing more long-term procurement so that they have plenty of time to get some of these resources that may be more up and coming, but will overall provide long-term benefits for customers and for the utility.
Okay. Thank you for that. I'm going to take a minute to look at what else I have here. Okay. I'd like to point you to your testimony in support of the stipulation at page 7, lines 14 through 18.
Okay.
And what you address there, you state that with SPS's request to flow the cost of market purchased energy used to charge the BES through its fuel and purchase power cost adjustment clause, interveners are interested in better understanding how the costs and benefits of energy arbitrage, a function of energy storage resources, will be allocated across the customer base, end quote. My understanding is that there is an energy allocator that is different than the demand allocator that is used to assign energy costs. And I've also seen testimony in this case regarding a possible, concerns regarding shifting of capacity costs from low load factor to high load factor customers if the fuel clause was used for capacity charges. That makes me start to wonder whether staff has concerns that the energy allocator inappropriately shifts benefits of energy arbitrage to high load factor customers in comparison to low load factor customers, because they use a large amount of energy on a very layman's statement, and therefore benefits might not be just and reasonably allocated to the different customer classes. I just want to put that on the table to see if you have comments on that.
Yeah, and that's kind of why, that's the energy allocator part was another intervener that was kind of asking those questions about what do we large users, larger user potentially get out of this arbitrage value. Now, again, the main reason for these capacity upgrades, the batteries, is for resource adequacy. Again, the arbitrage is, gravy on the potatoes or cream on the pudding. But yeah, I know what you're saying. It goes more to the big users now, and that's why we're really, again, PNM, not to say that they're doing everything perfectly, but they have been doing this pricing advisory committee process. We suggest that SPS do something similar and start this conversation where all the interveners can get together and discuss causation, cost allocation moving forward, because as your resources change, the variable resources, the old system basically assumes you have a coal-fired power plant and you just shovel more coal into it when you need it. And it's fixed. It's always there, it's always available, and you just throttle it up and down. Now it's all timing. Is that my solar running? Is my battery running? Does my battery have energy in it? Is the wind blowing? And who's using power at those times? And really, where is the utility's loss of load hours? Are they in the winter? If you're high on solar like PNM, winter is going to be a big problem moving forward, especially if everybody electrifies their heating and stuff. Winter starts to become the issue. So now you shift from a summer peak to a winter peak. And then with SPS, you have the other um, additive of the SPP PRM, the planning reserve margin, and it's doubling during the winter. Now, for some utilities that have really high summer peaks, a doubling of winter PRM is not a big issue, but SPS is pretty much steady state, summer, winter, fall, spring, it doesn't change much. So when SPP just doubles the PRM, all of a sudden SPS has to build all these resources to cover themselves in the winter. Now, the question is who's using all that power in the winter that drove this capacity demand? It's no longer the summer users. And then on top of that, all these batteries get a big hit on ELCC or accreditation in the winter. So again, the capacity value of, a battery in Roswell gets 38% accreditation in January, whereas you go 100 miles west to Albuquerque and it gets 80%. Again, a big shift in the value proposition of battery storage in 100 miles across the state. So those things I think need to be accounted for. It's not just the load anymore that varies, it's also the capacity or the accredited capacity of the generation resources that are constantly fluctuating. And sometimes it's not SPS that's driving that, it's a third party SPP that's driving that. And so we need a cost allocation system that better aligns with those changes. I think that's our belief, and so and we're very happy that SPS has agreed to take up that charge and start evaluating this again.
Thank you for that explanation. With respect to the stipulation in the agreement, I need to just pull it up again, but I'll ask you first before I have to pull it up. The agreements that have been reached in the stipulation to assess the allocation factors, will that incorporate assessments of energy allocators in addition to an assessment of the appropriate demand allocator?
What I don't know how everybody's understanding is of the stipulation, but I believe that was our understanding. It was be kind of a holistic review of that. And maybe the energy allocator doesn't need to change. But clearly if somebody's going to get benefits from the energy, then maybe somebody else should be getting credit for the capacity. So it may come out in the wash, but yeah, we were hoping it would be a fairly holistic view of rate making basically in SPS territory.
Okay, I'm going to take a second and just look at the exact language in the stipulation of the conditions for approval in section 1.3 on page 6. It's there. SPS shall convene a working group with stakeholders and staff to evaluate and analyze alternatives to SPS's current retail customer class cost allocation for both demand, capacity, and energy costs.
Yeah.
And the results of this analysis will be presented in SPS's next rate case. Okay. that brings me to the end of my questions. I don't, Mr. Hearing Examiner Schaefer, do you have any questions?
No, I don't. I think you covered a lot of the same questions that I had. Ms. Hamer, do you have any follow-up questions for Mr. Zigich?
No, no follow-up questions.
Thank you, Ms. Hamer. Mr. Zigich, once again, thank you for your participation in this case and for taking the time to be here with us today. You may be excused. Thank you.
Thank you.
Thank you, Mr. Zigich.
Well, I think we have one more witness, Ms. Hamer, that's Mr. Crespin. I think we just have a few questions for him. So I'm not sure he's joined. Go ahead, Mr. Hearing Examiner Gecko.
Based on my review over the lunch break, and the answers that I received from other witnesses, I personally do no longer have questions for Mr. Crespin.
Excellent. Well, maybe we'll just admit him and let him know that.
Is he getting on the Zoom?
Yes, he just was in the waiting room when Hearing Examiner Getco shared his thoughts.
Okay.
So we'll just wait for him to join and then tell him that he's no longer needed. Hi, Mr. Crespin.
Hello.
Thank you for taking the time to be with us and for your participation in the case. We actually have answered all of our questions from staff witnesses, so you are excused.
Thank you, Hearing Examiner Schaefer. I appreciate that. You guys
Yes, thank you so much. Take care. Well, and I don't believe, Hearing Examiner Gecko, you had any questions for OPL witness Mr. Lee, so I believe that brings us to the conclusion of our questioning for today. Is that correct?
That's correct.
Okay, well, we'll discuss some wrap-up items here in a moment, but I just wanted to ask the parties if they have any procedural or other concerns that they wish to raise at this moment. No? Okay. Well, first of all, thanks to everybody, staff, large customer group, OPL, applicants for your work in this case and for taking the time to be here with us, for parties counsel as well, much appreciated. Also, of great importance is our gratitude to our court reporter, Ms. Gonsalves. Thank you for taking the time. I think that Hearing Examiner Getco and I will discuss any post-hearing briefing once we're offline, maybe later this afternoon or tomorrow, and then communicate with the parties pending our decision and discussion. So unless there's anything else, Mr. Gecko, Hearing Examiner Gecko, would you like to share any thoughts or raise any issues before we conclude?
Only one more so that parties understand that we'll be thinking about it is that offline I'd like to discuss whether we ask for a proposed certification of stipulation. And so I think we can accomplish that in our discussion and in a short order to the parties based upon that discussion.
Well, thank you, Hearing Examiner Gecko. That's very well taken. And on behalf of the commission, we wish to express again our gratitude for all the hard work that goes into these and all the other cases that come before us. So thank you. And until next time, we're in recess. Thank you, everybody.
Thank you, everybody. Thank you.